record. Chapter 4, Fair Housing. In this chapter, we're going to identify protections of the federal fair housing laws, including enforcement, describe the protections of New Jersey's laws against discrimination, including state regulations on rentals, and we're going to discuss implications of the fair housing laws for brokers and salespeople. Are you ready?
Yes.
Alrighty, if not, here we come. Let's go. Let's do this. So, the equal opportunity in housing. Federal, state, and local laws about human rights and fair housing affect rentals and sales at every phase of the real estate transaction from listing to close. And failure to comply with the fair housing practice is not only grounds for the loss of your license, but it is also an unlawful act. And here's a little tip for you to remember. When two laws cover the same topic, the more restrictive rule will always prevail. It doesn't matter if we're talking discrimination or anti-discrimination stuff, or if we're talking zoning laws, whatever it is. When two laws cover the same topic, the more restrictive rule will always prevail. So, why do we have fair housing laws? Well, so everyone can have an equal right and an opportunity to have a place to live, whether it's to own or rent, and to be able to own your own personal property. Right? Remember, back in the days of slavery, you didn't even own the clothes on your back. So you could have a place to live. You have an opportunity to have a place to live, whether owning or renting. You know, your outcome is not guaranteed. If you don't work, you don't get stuff. Okay, you don't have an entitlement to anything. Okay, but you have an equal chance, an equal right to the opportunity to own real estate, or if you can't own it, then to rent it. And violating these laws is a criminal act. So it started way back in 1866. Who was president back then that did something significant when it came to civil rights? Anyone recall? That tall man?
Lincoln?
There we go. And what did Lincoln do?
He stopped the slavery.
Yeah, so he passed the Civil Rights Act of 1866.
16. Mm-hmm.
So this was an outgrowth of the 14th Amendment of the United States Constitution that prohibited any type of discrimination based on race and or color. It said that all citizens in the United States have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey both real and personal property. So this law deals with race and color, and the type of property it covers is all property, because there's only two types of property on this planet. It's either real estate, that's real property, or personal property, like the clothes on your back, your car, your jewelry, things of that nature. Because of the reference to white citizens, this law has been widely interpreted to prohibit discrimination based on race and or color. So that's the protected class there, even though later on they did add two more protected classes, which we'll see on the next slide. Now, in 1968, the Supreme Court decision of Jones versus Alfred H. Mayer Company, they reduced this to just a blurb here in the book, but this used to be a whole section talking about this court case. It basically was the Alfred H. Mayer Company discriminated against Jones, and he sued, and the Supreme Court said that because there's one law that allows you to, that has exceptions to it, doesn't allow discrimination, but it has some exceptions to it, which the Alfred H. Mayer Company tried using race as the exception. But when it comes to race and color, they ultimately held that no exceptions are allowed for race and color. Under no circumstances, even though one law may have some exemptions to it, it does not mean that you can ever discriminate on the basis of race or color. And the Civil Rights Act of 1866 said that. And even though they came out with another law in 1968, you still that has some exceptions to it, where you still fall back on the older law that has no exceptions. Remember, I told you, when two laws cover the same topic, the most restrictive rule will always prevail, meaning you always have to follow the most restrictive rule. And the most restrictive rule says that when it comes to race and color, you can never discriminate. So here we go. We got a slide here for this. Civil Rights Act of 1866. It's part of the 14th Amendment of the United States Constitution, granting equal rights to all citizens for ownership of both real and personal property, all property. When it comes to race, there's no exceptions to this federal law. All types of property are covered by this law, all real estate, residential and commercial, including unimproved land. Personal property, like the clothes on your back and your other personal belongings, like your cars and jewelry and such. And the protected classes are race and color. Although much later in 1987, they added ethnicity and religious groups to the protected class of that law, the Civil Rights Act of 1866. When it comes to enforcement and real estate, at least the real estate provisions, it's enforced by HUD, the Department of Housing and Urban Development. So violations under the Civil Rights Act of 1866 must be heard in federal court, and the statute of limitations is determined by your state law. Federal court has no monetary caps on the awards and settlements that it grants out anyway. So, not a bad slide to add to your slideshow there, right?
Yeah, perfect. Nice information.
Yep, pretty direct there. All right. Let me pull out my Word document. I want to be updating that all the time, so you guys have your notes, making those notes there for you. Okay, so we left off here, and this is chapter. Going back and getting some of these slide information right now. Oh, so right side 6. Okay, sorry for that delay. So the Federal Fair Housing Act of 1968, the Federal Fair Housing Act, in its name, it has the word housing. So what kind of property does the Federal Fair Housing Act of 1968 deal with? There's a hint in the name.
Residential.
Residential real estate, correct. So the Federal Fair Housing Act of 1968 is contained in Title 8 of the Civil Rights Act of 1968. It prohibits discrimination on the basis of more protected classes here, 7 to be exact: race, color, religion, national origin, including the origin of your ancestors, sex when selling or leasing residential property. They didn't list all 7 just yet. We're going to get into all 7 protected classes. And when selling or leasing residential property. So the law impacts direct providers of housing, including landlords and real estate companies, as well as municipalities, lending institutions, home insurance companies, etc. So, the Federal Fair Housing Act of 1968 has a section in it dedicated to housing. Remember the whole civil rights movement of the 60s? Well, you may not have been born, but either way, you should have heard of it, right? The Civil Rights Act, the big civil rights movement in the 60s, 1968. It was a whole body of laws that were passed for anti-discriminatory legislation. So the Civil Rights Act of 1968 had a section within that law dedicated to housing. It was called Title VIII. And Title VIII is also known as the Federal Fair Housing Act of 1968. Okay, which is a part of the whole Civil Rights Act of 1968. The section within it, Title VIII, is called the Federal Fair Housing Act of 1968. These are not all a bunch of different laws, okay? So we're all talking about the same thing here. Civil Rights Act of 1968 was a whole body of laws to protect people, to prevent having separate bathrooms for white people and black people, and, you know, where you could ride on the bus, and if you could go to the same school. It prevented segregation and all kinds of other things of that nature. Even though today, oddly enough, you're seeing a lot of the young people who never had to deal with that stuff. They're like, we need our safe places away from everybody else, basically trying to segregate themselves again, which is kind of stupid. But hey, they didn't fight for those laws. It was their ancestors that did, and they don't appreciate it. And this is what they yell for these days. And yet these are kids in college. You know, we need segregation for our safe spaces. No, you don't. Everything needs to be integrated here. So the Civil Rights Act of 1968 was the entire big body of the law. One more time, I'm going to explain this. And a section of that law was called Title VIII, and it pertained to housing. So they named it the Federal Fair Housing Act of 1968. That's what Title VIII is also known as. So the type of property covered is residential property, whether it's for sale, lease, or transfer. And that includes vacant land for residential use. So this has nothing to do with commercial property or personal property. This only has to deal with residential real estate. The protected classes are race, color, religion, national origin. Amendments later also added sex in 1974, pertaining, when they say sex, it is pertaining to protections for women. It has come to be blown up into something more than that these days, but it is protection for women. People with disabilities, including AIDS, and familial status. That means people with children. That includes pregnant women and foster kids. Alcoholics and persons in drug treatment programs are considered to be a protected class. However, under the federal law, current drug abusers or people who pose a threat to the health and safety of others are not a protected class, even though many states are now legalizing some drug use. They don't trump federal law, so to speak. You know, they don't overrule the federal law, which makes it still illegal. You know, we see all these marijuana dispensaries popping up here in New Jersey. Hell, in New York, they have stations set up where people can shoot up their heroin or whatever, you know, which is illegal, but they're making it easier for them to do it, so it's safer for them. Either way, it's illegal. If the feds wanted to at any time, they could swoop in and shut all that stuff down. The states can't pass laws making something that is specifically illegal under federal law legal, you know, and you're seeing that as A lot of states tried making their own sanctuary policies. You know, we're a sanctuary city or we're a sanctuary state. And you see the feds going in there and immigration enforcement coming in and swooping up people now because states cannot overrule the federal law. So enforcement activity is done by HUD once again, the Department of Housing and Urban Development. If you feel like your rights were violated under the Fair Housing Act of 1968, you have 1 year to file a complaint to have it heard by an administrative judge within HUD. Yes, they have their own judges that all they do is listen to cases of discrimination under the Fair Housing Act of 1968. And if you want to make a federal case out of it and have it heard in federal court, well, then you have 2 years to take the action to court and have it heard in the federal court where there are no monetary caps on the awards and settlements. In the court, in HUD's court, there are monetary caps for awards and settlements and fines, which I'll show them to you, but you don't need to study them because they are obscure numbers. I don't even know how they made them up. And I don't know how you would remember it. Yeah. Oh, okay. I thought somebody was asking a question. All right, so let's do these highlights here. Under the Federal Fair Housing Act of 1968, on page 68. Look at that. So I had to write in the extra missing protected classes that they put in here on the 1, 2, 3, 4, 5th bullet point. And on the 6th bullet point, you also write in this redlining here. Let me know when everybody got those highlights. I'm going to move to the next slide where I typed all this stuff in and I made some slight modifications to the wording.
Yeah, did.
Everybody got it?
Yeah.
Yeah.
Okay. So Civil Rights Act covers dwellings and apartments as well as vacant land acquired for the construction of residential buildings. And it prohibits the following discriminatory acts: refusing to sell, rent, or negotiate with any person, or otherwise making a dwelling unavailable to any person as a means of discrimination. Changing terms, conditions, or services for different individuals as a means of discrimination. Practicing discrimination through any statement or advertisement that restricts the sale or rental of residential property. Representing to any person as a means of discrimination that a dwelling is not available for sale or rent, when in fact it is. Or making a profit by inducing owners of housing to sell or rent because of the prospective entry of the persons of a protected class into a neighborhood, based on their race, color, religion, national origin, sex, disability, or familial status. Those are all the protected classes. It is not just race and color. There are 7 protected classes here. Let me see if I got them all here. 1, 2, 3, 4, 5, 6, 7. Yes. These are all 7 of the protected classes under the Federal Fair Housing Act. And when this is done, it's actually called
I have one question.
or panic peddling. Yeah, go ahead.
So when this saying race, color, religion, national origin, sex, disability, and family status is the protected. Protected from whom?
Those are the protected classes. This law protects for all of these things I am explaining right now. Who is protected by this law?
No, when we saying who, then definitely there will be some whom. You are protecting
Yeah, who are you
from
protecting?
what?
People of a protected race, color, religion, national origin, sex, disability, or familial status, you're protecting them from these discriminatory acts.
So when we're saying race, then everyone is covered in the race.
Yes,
All human society is covered in the race.
yes.
So
Whether the person is black or white, yes, you can discriminate against white people too. Even though some people who tend to throw this thing around that you can't discriminate against white people, they're being racist. It doesn't matter your color. You cannot discriminate on someone based on their race or color, or religion, or their national origin, or their sex, or their disability, or their familial status. Okay, these are the protected classes under the Federal Fair Housing Act of 1968. Now since then, you get a lot of other laws that are being passed, that allow people based on not sex, but they included this word gender, and then they expanded that to be gender identity. The word gender was invented, I believe, in the 70s. It was actually a professor in college. He wrote a lot of taboo books. Let's just leave it at that he wrote a lot of taboo books, and he liked to push the boundaries on people to be a shocking person. And it actually picked up and became like a whole movement thing that this idea of gender. There is no such thing as gender. Gender is something that's mental. It's something that's in your head. Okay, so that's why now they say, well, you could have 50 different genders. Okay, because there's only two sexes, male and female, but you can have many different genders because gender is a made-up concept that's in your head. This is why these things get all exploded out of. But the thing is, some point in time, government started adding gender on forms.
Yeah, on the forms asking what is your gender.
Who slipped that in? And so now it's like we don't go back in history to try to trace these things and say, wait a minute, how did this even become a thing? You can easily trace it back to, let's see the first forms where it was added. But anyway, these are the protected classes, and there are more now because of over time and the way society changes and all that. But these are the ones under the Federal Fair Housing Act of 1968 today. So let me read this one at a time. Making a profit by inducing owners of housing to sell or rent because of the prospective entry of persons of a protected class into the neighborhood based on their protected class. This is known as blockbusting or panic selling because you're trying to scare the homeowner into selling their home, trying to get them to bust up the block by selling some sort of a scary story to try to instill panic in them. These people, they're going to drive the crime's going to go through the roof. Fill in whatever the line is, and it could apply to anything.
Your voice is breaking, Victor.
Huh?
Sometimes your voice is breaking. It's very low voice is coming sometimes.
It could be the internet connection. Is everybody getting it or just him?
Yeah, it sometimes happens, like your voice fades in and out.
Okay.
Yeah.
That's weird. Okay, then it's probably the Zoom app.
Yes, maybe.
I got a gigabit connection up and down here, so I got a fiber gigabit connection. So I don't think it's my connection. It's got to be the Zoom app then.
Yeah.
But yeah, lots going on with all the video information going back and forth and me talking. So okay, so it's basically blockbusting and panic peddling. I need you to understand what it is. It's basically trying to scare the homeowner by telling them a scary story about one of these protected classes to try to instill panic in them. That's why it's also known as panic peddling, to try to get them to sell their home.
Okay, so you mean that as a seller agent, buyer agent, or the seller agent, we are panicking the sellers that, hey, this offer is came from this protected class, so we have to accept this offer, otherwise they may can explain something.
This better not be you. This
Yeah,
better
that's what I'm
not
saying.
be-
That is called a panicking the sellers.
Okay, so this came up. This started um, started long ago. Started in the '60s there, where people start when we started passing all of these fair housing laws and stuff, and the desegregation and things of that nature. Remember, all this stuff started in 1866. You know, and then what happens is because the president proclaims there's no discrimination, that all people are created equal. Everybody's not going to instantly be like, okay, you're still going to have your racists, you're still going to have those people that wanted slaves, So it takes time for society to change and accept the changes and all that, right? So we've been making these changes, but we've been trying to and improve our society, People who keep hanging on it in the past. Well, in the past. Well, don't look in the past. Look to the future. Try to improve things. Stop looking in the past. Try to look to the future to improve things. Otherwise, you're slowing this progress down. So, back in the '60s, you were having people that they didn't want this. So what they were doing is, well, actually, I don't think they really cared one way or another. I think they just saw these were opportunists that saw an opportunity to make money. So you were even getting like these investors. You were getting investors together, and they would even like pay a young black girl or a Hispanic girl or some ethnic minority. They would pay to push a stroller down the street. Like everybody's in on the same scheme to try to screw people out of their houses by scaring them. So they would knock on a door and they'd say, "Hey, listen, did you hear who's moving into the neighborhood? These people." And they're going to be taking over, and they're going to ruin the prices are going to go down. It's going to this and that and the other thing. They're making these scary scenarios up, and then they have this girl pushing a stroller down the street right behind them. They're like, "Look, it's happening already." It's a thing they actually did, and they would scare the person into selling their house, and they say, "So, but we are here." Are willing to offer you to purchase that house from you and bury you out of it. Now, of course, they're not going to pay you top dollar because property values are going to be going down and all, but we will give you the best that we can in this situation. And then what they would do is then they would turn around, and once they got that house, they'd turn it around and they would sell it to the very protected class, the minorities groups that they were trying to paint the scary story about. Of course, they would sell them at a marked up price, though, and then they'd go to the neighbor's door, and this is blockbusting. Okay.
Okay, got it.
It's spreading fear and panic. This wasn't real estate agents doing this, or definitely shouldn't have been real estate agents doing it.
This is all business.
Yeah, these are a lot of investors. All they cared about was the money. They were opportunists, and they saw this as an opportunity to make money. And they playing on people's fears of the change that was going on because people are scared of change,
Yeah.
So altering terms or conditions for a home loan or insurance policy to any person who wishes to purchase or repair a dwelling, or otherwise deny such a loan as a means of discrimination, even though they could afford it. That is called redlining. An easier way to remember this, that it deals with home loans and insurance policies, is both of those things deal with the money, the financial aspect. And think about it, when you use, when you're talking about finances and you use red ink, is that a positive thing or a negative thing?
It's a negative things.
Or when you're talking about finances and you're using red ink, Do you want to be in the red or you want to be in the black or the blue ink?
I will be want to be in the green, not on the red.
So, the bookkeeping, it's either, the black ink or the blue ink, whatever. But being in the red is, you don't want to be in the red. It means you're behind or it's a bad situation or whatever when it comes to finances, when those financial experts are using red ink. Okay, so try to use that as a visual. When you think about the finances, this is what redlining is. Try to think of red ink, and it deals with the home loans and insurance policies and denying people them, even though they can afford them. They use that as a way of denying them. It's called redlining. All right. Now, that's not where the term redlining comes from. I will show you where the term redlining comes from in a moment. But I was just trying to give you a visual of trying to remember that it deals with redlining, deals with not giving someone a home loan or an insurance policy, even though they could afford it to make the payments. Okay, so denying people membership or limiting their participation in a multiple listing service, real estate brokers organization, or other facility related to the sale or rental of dwellings as a means of discrimination. So I can't be denied, me, Victor, a white male, I cannot be denied a membership in the African American Association of Realtors or the Hispanic Association or Women's Council or Asian Association of Realtors, etc. Because that would be discrimination because it's based on a protected class, which is race, right? You can't deny me because I don't fit in that particular protected class. All right. So some exceptions to the Federal Fair Housing Act of 1968 went into effect, but never on the basis of race and color. Yeah, I'm going to have to write that in on my notes here too. So some exceptions to the Federal Fair Housing Act.
Yep.
Yeah, I got to write this in. Give me 1 second. I'll write it in as you do your highlights too. So some exceptions exist to the Federal Fair, I think, 1968. However, there are no exceptions when it comes to race or color. Period. All right. So the sale or rental of a single-family home is exempt when a home is owned by an individual who does not own more than 3 such homes at one time, and when A, broker, salesperson, or agent is not used, and B, discriminatory advertising is not used. If the owner is not living in the dwelling at the time of the transaction or was not the most recent occupant, only one such sale by an individual is exempt by the law within any 24-month period. The rental of rooms or units is exempt in an unoccupied 1 to 4 family dwelling. Dwelling units owned by religious organizations may be restricted to people of the same religion if membership in that organization is not restricted on the basis of race, color, national origin, disability, or familial status. Now, we're talking about dwelling units owned by a religious organization, not by religious people, okay, individuals. A private club that is not open to the public may restrict the rental or occupancy of its lodgings that it owns to its members, as long as those lodgings are not operated commercially. In 1968, the 1968 Act was amended several times over the years, and in 1988, they added mental and physical disabilities, including things like AIDS, or today you could even add in there COVID-19 and things of that nature. 1988, they also added familial status, that is, having family members under the age of 18. This includes pregnant women and foster children. In 1995, Housing for Older Persons Act, HOPA, they added protected class, an exemption from the familial status was for housing that was intended to be strictly for older persons. So it is not considered discrimination against people under the familial status because they don't allow children there, people under the age of 18, because it's meant to be housing for older persons, 55 plus communities or senior housing. Now, in 1974, the Federal Equal Credit Opportunity Act, ECOA, made it illegal for creditors to discriminate against applicants because they were women. Now, here in the book, they kind of lost track of that. This is why this law was originally passed, was to protect women. Although they just throw in all the protected classes. Because back then, you get a woman that tries to get a loan to buy a house or a car, and you'll be like, oh, lady, she wasn't taken seriously. She's like, hey, why don't you go home and bring your husband back so the men can talk over the finances? It was considered the homemakers, not the workers or the owners or anything. And this is why we had that women's lib movement in the 70s, because the women's liberation movement, or lib movement, because they were discriminated upon by men so much. So the Federal Equal Credit Opportunity Act, it basically says that if anybody's ever denied credit, the person who's providing the credit that did the denying has to provide that person within a certain time frame, a reason in writing why they denied credit, so that we can see if this is because of its discriminatory purposes or not. But this was put into place to protect women, even though now they say it's because of their race, color, religion, national origin, sex, marital status, or age, or the fact the applicant receives income from public assistance programs or exercised any right under the Consumer Protection Act. Women thus had access to more housing opportunities. Oh, there you go. Yeah, they throw the women in at the last moment there now, because this law was actually initially created to protect women. Now it protects all the protected classes, of course, but women had it really hard there because they couldn't, they had trouble getting credit or taken seriously when it came to the financials. All right, so alcoholics and persons in drug treatment programs are a protected class under the disability requirement. Or the disability protection. However, drug abusers or users of illegal controlled substances are not considered a protected class. Although in some states like New Jersey and New York and, Washington State, California, some places like this that legalized the drug use, they may not get prosecuted, but under federal law, it is still, these are still the rules. So you can't sue under federal law for this. Maybe your state has some laws with protections that would allow you to sue because maybe a drug user is a protected class, but Under the federal law, drug users are not a protected class unless they're in treatment programs trying to get better. And then you can't discriminate against them because, hey, they're trying, you know? So other persons who are not considered disabled include persons convicted for illegal manufacture or distribution of a controlled substance, sex offenders, and juvenile offenders. Although some states, like the state of New Jersey, has made a lot of classes of criminals a protected class, which we'll get into and I'll show you. So, for instance, in New Jersey, when we get into New Jersey's law against discrimination, it is illegal to discriminate against someone because they went to prison for the manufacture of meth. They had a meth factory in your mom's kitchen, in the apartment they were renting in your mom's house. Okay, you can't discriminate against this person. They served their time. They're a protected class now. They served their time. Well, the weird thing is politicians always carve out rules for themselves so that they don't have to follow the same rules. Because under the same situation, if that person who was running a meth factory in a federally run housing complex, then you can discriminate against them. But if they're running a meth factory in your mom's kitchen, you can't. It's discrimination if you deny renting to them. All right. It sounds crazy, doesn't it, when I say it like that?
So I have a question.
Yeah.
Just to clarify, so if they're considered in the protective class, we have to work with them as agents, but if they're not considered a protected class, then we have the right to refuse to work with them?
Yeah, you don't have to work with every junkie that comes in the room, right? Especially if you don't feel safe with somebody, you could put them to another agent to work with, you know.
Okay.
Look out for your own safety first. Okay.
What about someone that has a criminal record? Are they considered protected class?
In New Jersey, yes.
Okay.
Well, we didn't get to that just yet, but that's what I was explaining just now about that meth factory in your mom's kitchen, you know.
Mm-hmm.
The politicians in New Jersey thought it was wise to say, hey, yeah, you know what? They went to prison for that and they served their time. They've been rehabilitated. You can't discriminate against them now and not rent to them because they ran a meth factory in somebody's mother's kitchen. However, if it was done on a federal housing project where they ran that meth factory, you can discriminate all you want against them.
Okay, thank you.
They carve out exceptions like that for themselves, you know. This is why I say that hypocrisy is so great, you know, about who when it's considered discrimination and when it's not considered discrimination. You know, it's New Jersey and some other states. I mean, it has to deal with politics. It boils down to politics. You know, I hate talking about it, but I always end up talking about it because these are political issues that affect these laws, that created these laws, that affect us as homeowners. You know, you want to rent out to somebody, you got to follow these laws. And states like New Jersey are creating some wacky laws. You know, we are a liberal state, but we're so liberal that I think our minds have fallen out of our heads with some of these laws that we're passing, you know? And look, don't take my word for it. I'll show it to you. I'll show it to you in the law. So let's look at this next slide. Exceptions to the familial status. Let me first take those other screenshots and add them to the notes. And again. All right, so familial status, you cannot discriminate against those with families, adopted or foster children, particularly with children under the age of 18, including pregnant women. There are some exceptions to the familial status protected class in housing meant for older persons that would not be considered discrimination. And that would be because of the passage of HOPA in 1995. That's housing for older persons. Senior housing is housing that is strictly for seniors 62 years of age and older. So it's housing occupied only by people 62 and older. And they post by the entrances that the property complies with HUD's rules that the housing is meant to be for older persons. We also have 55 plus communities. Now, what is a 55 plus community? It is a community where at least 80% of the units are occupied by at least one person 55 years of age or older, and the housing facility and community posts and adheres to policies that demonstrate its intent to be housing for older persons 55 and older. So can you own a property in a 55 plus community and not be 55 and older?
Yes, technically, because only 80% of the units need to be occupied by 55 plus.
Correct. So what kind of situation would that occur? Maybe you were married to someone who was younger than you, perhaps, right? And maybe you pass away and you left it to them. Or maybe you had your adult child living with you and you were 55 and older, and then you pass away and you leave it to your child and they can continue living there. As long as the community keeps track of this and not more than 80% or not less than 80% of the units are occupied by at least one person 55 and older, we want to make sure that they keep in line with that. But how about this one? What about senior housing 62 and older? Can you be under 62 and purchase one of these?
Yeah, that was my
No.
question. Can you purchase a 55 plus home before you're 55?
I think no.
Oh, so, you know what? We'll table that question for a second and we'll just keep it right now with living there. In a senior housing, can you be under 62 and live there?
No.
No, because it's strictly for people 62 and older.
Right.
Now let's get to that question you just asked. Can a buyer younger than 55 years old purchase a property in a 55 plus community if they're going to rent it out to persons 55 and older, and the community allows rentals? Can each individual homeowners association determine an age restriction on the age of the buyer? So this is a question that was posed in that New Jersey Realtors Legal Questions Library to the attorneys there for that usually answer these things for New Jersey Association of Realtors. And the answer is, let's see what the answer is. Hold on a second. Let me just copy this question down and put it in our notes here. Oh. Going too fast. Okay. So here is the answer. I have the link to it right here on the left-hand side, but you guys are not going to have access to this link because you need a login for it until you become realtors and you have a login to this. Then and only then can you have access to this non-legal library where you can go through questions and you could even read, submit questions and then get answers from New Jersey Realtors legal attorney staff. So the question here is about the buying in a 55 and older or 62 strictly community. New Jersey law requires that all purchasers or grantees of homes in an age-restricted community certify that the homes will be occupied by individuals who meet the age restrictions of the community. Neither the federal nor the state law requires a non-occupant owner or grantee to meet the age restriction as a prerequisite to purchase or obtaining title to property within the age-restricted community. That being said, New Jersey Realtors is aware that some homeowners associations and municipalities have enacted governing documents and zoning ordinances that require the owner to meet certain age restrictions. Well, why are these municipalities and these buildings doing this? Well, because why do we have age-restricted communities to begin with?
For their protection and their safety.
Well, for them to get an affordable place to live, because they tend to be a lot cheaper than the same building if it were not.
This is not for the safety. This is mainly for the price.
Yeah, it has to deal with
The
maybe
main is income. The age of 55, you have slowing down your income. So
you can get these places cheaper than a similar place that was not in an age-restricted community.
yes.
And you get tax breaks too. But the so selling it to people who are younger, who may be purchasing it as an investor, you're going to turn around and mark it up and now rent it out at a higher rate to the seniors. It kind of defeats the purpose of the senior housing, doesn't it?
Mm-hmm.
So I understand where they're coming from, and I actually back that agenda. With the only thing is maybe they could put something in the law that says you could be younger than 55 and purchase in these communities if you're purchasing for maybe a relative that's older. You know, you're like purchasing a property for your parents or grandparents or something to live in. You know, otherwise, you know, these are investors basically marking it up, and it's kind of defeating the purpose of the whole senior housing. So these laws could be crafted a little bit with those types of situations carved out. But the Realtors Association, they're always like, nope, we always want to encourage sales and purchasing no matter what, under any circumstance. So they were totally against this because they just want sales. Okay, so the so even if the owner would not be occupying the home, so it's New Jersey Realtors' position that HOA regulations or housing for older, homeowners associations, HOA associations, or municipal ordinances which prohibit non-occupying individuals under 55 or 62 from owning a home in those age-restricted communities, even when a certified occupant will meet the age requirements, violate the federal and state laws. So for this reason, New Jersey Realtors is currently challenging the legality of such ordinance in court. And the matter is currently before the New Jersey Appellate Court, and we anticipate a decision in the coming months. That was January 12th, 2024, and they did come up with a decision since then that I will show you on the next slide. What do you think they did? Which way did they go?
That you can't own if you're under 55.
That's wishful thinking.
Oh, yeah?
The matter was decided. Hey, I'm with you on it, though. You know, the matter was decided by the New Jersey Appellate Court in New Jersey Realtors versus the Township of Berkeley in July 2024, where the court agreed that New Jersey Realtors and that it is the age of the occupant, not the age of the owner, which matters. As someone under the age of 55 or 62 as an applicant cannot be precluded from purchasing a home so long as they certify that the occupant will meet the community's age restriction requirement. So the court subsequently invalidated the local ordinance in question. And there were a lot of communities, a lot of them in Monmouth County that were doing this as well. So, 55 plus communities, anybody can buy them now. It's just a matter of that they can't occupy them or live in them unless you meet the age restriction requirement. So, yeah, here are the links to that NARS or New Jersey Realtors legal diary where I got these screenshots from. Okay, and so that's the rule on it now. So some people do agree with me on this, right? It's not just me standing out there thinking that it shouldn't be like this, that it should only be that you got to meet the age requirements in order to buy in these places, or be a relative of the person and not an investor who's going to be up the prices.
As you said on the beginning, then it's dissolve the purpose. Then all the investors are gonna buy in the cheaper price and then rent to the 55 plus into the higher rate.
Yeah,
so
exactly.
That's again investment.
Exactly.
Real people never gonna get this house in age of 55.
So every break we try getting seniors to stay in New Jersey, we keep taking it away from them, pulling the carpet out from under them. New Jersey's not a cheap place to live.
Yeah.
So here's some. So these are the exceptions to the familial status again. The state and federal programs for elderly persons, the HOPA, intended to be solely occupied by persons 62 and older. That is called senior housing. And those that are intended to be occupied by people who are 55 and over, that is a 55 plus community. And those are the requirements to be considered then. This is a form that the Garden State MLS uses, but a lot of other MLSs use it too. They just put GSMLS there at the top. It's the same form basically. If you're getting a listing and you're putting it in the MLS and it is housing restricted based on age, if you put a listing in the MLS and you put in there some kind of a wording that it's age restricted, that's a discriminatory advertisement. Unless you also get the owners to submit this form, and you submit it to this form now. You get the owners to fill out this form, and then you submit this form to the MLS with the listing. Then you've got your proof there that it is a age-restricted community. So this is the Housing for Older Persons Certification of Compliance. Okay. Back to my notes. So service animals. So Fair Housing Act, the FHA, not the Federal Housing Administration, but the Fair Housing Act, FHA, makes it unlawful for housing providers to refuse to make a reasonable accommodation that a person with a disability may need in order to have equal opportunity to enjoy and use a dwelling. Assistance animals are not pets. They work, perform tasks, assist and or provide therapeutic emotional support for individuals with disabilities. These are what service animals are. They are not pets. They're considered consider the assistive animal as part of the person's disability. So there's two types of assistance animals. We have service animals, which under the Americans with Disability Act requirement are trained to perform to assist, provide a service to the person with the disability. And there's another type of assistance animal that's called an emotional support animal, which they don't need any kind of training, simply having them that you could pet. Calms your nerves, perhaps, maybe people with PTSD or something like that. Just the fact that you have the animal helps the person emotionally. So the ESA provides therapeutic emotional support for individuals with mental health or emotional disorders like depression, severe anxiety, or phobias. So if you have a landlord that has a no pets rule, or they charge you a fee to have a pet, if you have a service animal or emotional support animal, they cannot charge you any fees. The landlord may not inquire as to the nature of the person's need, only the right to verify that the letter is from a therapist and it is a real therapist that is licensed and confirms the tenant has a need for an emotional support or service animal. See, a landlord, even though they have a no pets policy, they cannot refuse service animals. Or,
Can they have a no animals policy or that they can't do?
even if they have a no pets policy, correct? No,
So-
you tried rewording it and being slick there, saying no animal policy.
Right.
No. No.
Okay, it's all on the same, basically.
That's like saying we have a no persons with disabilities policy. Because remember, they said consider the assistance animal as part of the person's disability. That's the way the law looks at it.
So what is the example of service animals and what is the example of emotional support animals?
And any animal, just the fact that you have it helps you mentally. You could have a cat, you could have a dog, you could have a bird, something that helps calm you emotionally. It helps you with your severe anxiety, your depression or phobia, just by having the animal and maybe singing to the bird or singing with the bird or petting the cat or the dog, just the fact that you have them.
What about a horse?
But you know what? You give an inch, people take a mile. Yes. Service, technically, see, these are assistance animals. Now, there's also a classification called service animals. Service animals are ones that assist, like they detect oncoming seizures or when your blood sugar is running low or things of that nature. And only a dog can be a service animal in that nature, in that arena. However, in some instances, a miniature horse can be considered a service animal, provided the structure can handle them.
Yeah, no, I know that a horse, some people have a horse, I don't know for what reason, but is there a specific thing? Like I know somebody who has a horse, but they can't leave it on their property because it's not you're not allowed to have a stable on there or something like that. Could it fall into that category?
Well, it's not a horse, it's a miniature horse.
Right, no. So yeah, no, I'm talking about a full-size horse. Could you say that you can't have that on the property?
Yeah, a full-size horse can't be a service animal. We're looking at a full-size horse to live in somebody's house. That's just not safe.
No, so let's say have a stable on the property that they can ride, I'm talking more as a ESA animal.
I'm talking about living in the house with you.
Oh, okay, I get it.
Or going to the plane with you. Or going to a restaurant with you. Because service animals cannot be restricted from these places because the person has a need for them at all times. You're not going to have a need for a full-size horse at all times. However, a miniature horse is more reasonable, even though it seems kind of not. It's still kind of wacky. But a miniature horse, and a dog. So only dogs can be service animals. And if you notice, the service animals are usually large dogs. And there's a reason for that. Because when people tend to have illnesses that where they got seizures coming on or things of that nature, the dog needs to be able to guide the blind, needs to be able to be big enough to pull them in one direction or another, or to stop them, or to stand in their way to stop them and not get tripped over, right? Or if you notice service animals, have you ever seen any videos of service animals when people are starting to go into a seizure or something? The service animal will lean into them. They push their weight into their owner because that's their way of notifying them. Or their blood sugar is running low. They start hitting them with their snout. A little dog. Usually not a service animal like that. They're usually more emotional support. But yeah, the whole idea with the horses is something with stables and all that. Yeah, we're talking about actually living in the house where your landlord can deny you having a pet living in the home. These are not pets; these are service animals. Only a dog can be a service animal, but in some cases, a miniature horse. So you can have a miniature horse actually living in the house with you, and your landlord cannot deny it.
I have another question, teacher, and it's probably off topic, but I have seen houses where they have chickens. One day when I went to Monmouth County, there was a house that had chickens. I'm like, is it legal in some towns to have chickens on your property?
Yeah.
But
You can get individual houses, not
Yeah.
apartment.
Not roosters. The roosters are the one that do all the crowing. Yeah, 4 o'clock in the morning,
yeah. So it's legal as long as you like.
It may be, depending on your town's ordinance, because some pheasants can spread diseases and such too. So it may be. I got a friend; he's got 2 chickens. I got a cousin; she's got maybe 4 chickens. Because they lay eggs every day. And as long as they're healthy, and they lay eggs every day, so they got their chicken coops set up and everything, and they maintain them. But some municipalities may have ordinances against it. You got to check with what your local ordinances are. But most of them usually have an ordinance against the roosters. Those ones that are making the noise, and they walk around the neighborhood all over the place. I remember a house that I used to live in, the house next door. After I moved out of there, long after. Somebody knocked down the house and built one huge house and has a big yard on the corner, and there's no fence. And they got a bunch of chickens in their backyard. Like they got it's like a mini farm type facility. They must eat a lot of eggs. I don't know, or they got their own slaughterhouse inside. I don't know what the hell they're doing, but they got a lot of chickens. And they also had a lot of roosters. I seen 3 or 4 roosters. And I was like, what the hell is going on over here with all these roosters? They're just like walking around the house, around the perimeter of the house, on the outside, because they had no fence or anything. And I'm like, what the heck is going on in this neighborhood here? You can even hear them. I was like, oh my God, I couldn't live there. That would annoy that. It's right around the corner from my brother's house. I was like, oh, that's crazy. But I seen somebody must have complained because they eventually got rid of them, but they were there for a couple of years. Okay, so
Okay.
so a valid letter is written on a mental health professional's letterhead, along with their contact information, their phone number, email, and their practice address, so that we know that it is a legit thing, not one of these ones where people go online to a website to have their pet registered as a service animal so that they can live in the house and the landlord can't deny it. Those are all scams. Because, especially the ones that are like, and if if your landlord gives you static about it, you could just direct them to our website where they could search our database to see the certification that your pet has been certified as a service animal. That is bull. You know, we have something called HIPAA laws. You guys are familiar with HIPAA laws?
Yeah.
Privacy laws. There's no database where somebody can search to see if you have a medical need for a service animal. That's nonsense. So, but a lot of people, they really want to believe it so bad. So they go to these websites and they pay to have their pet certified or registered as a service animal. And then they send you a certificate with a number on it. And they give you the opportunity to buy the service vest for them and the card that you could carry with you and all kinds of stuff. It's bullshit. It's just somebody's trying to sell you garbage. You don't need that. All you need is a letter from a therapist for your landlord. Anybody else, you could take that service animal to a restaurant. They could only ask 2 or 3 questions. Is that a service animal? And what function do they perform? That's it. They can't ask anything else. Otherwise, they're discriminating against that person with a disability. Now, the laws have changed though, because a lot of people, you give them an inch, they take a mile. So you're seeing people taking emotional support animals everywhere too. And the restriction on what is considered an emotional support animal, people really push that too. So Congress, this had to go back to Congress. Congress actually changed it so that an emotional support animal is not allowed in the same places as a service animal would be. So you don't have to allow emotional support animals on planes and in public spaces like courthouses and restaurants, the beach anymore. Only service animals. Okay, so shops, business, and public buildings such as courts and libraries are legally required to admit service animals, even if their general policy is that no dogs are allowed inside. They are not required to accept the emotional support animals, which we used to see people all the time bringing their dogs in their pocketbooks or in a stroller or what have you, bringing them into restaurants or just letting them loose in the restaurants and these public accommodations. So because people, you give them an inch, they'll take 10 miles. So this had to have been changed in the law, and it was. All right, so service animals under the Fair Housing Act, the federal law prevents discrimination against tenants in their homes. A landlord would be guilty of discrimination if they violate the tenant's rights, providing them with a reasonable accommodation for a service animal, which could be assistance animals that perform tasks, or emotional support animals to soothe a mental condition when a tenant has provided a medical professional's prescription for one. Which, by the way, that prescription needs to be renewed every year. Under the FHA, a disability is defined as a physical or mental impairment which significantly limits a person's major life activities. Even if a lease says no pets or restricted pets, landlords are required to make what is called a reasonable accommodation to allow pets who serve as assistance animals, which includes animals who provide emotional support. Those are the ESAs for short. Assistance animals are in a different legal classification than pets who are not assistance animals, which is why pet restrictions and fees are waived for them. They are animals that will assist or perform tasks and services that benefit the person with the disability, providing emotional support that improves the symptoms of their disability. There's no official certification or training for assistance animals, and they can assist in a wide variety of ways. Breed and weight restrictions do not apply to assistance or service animals. So yes, even a pit bull can be an assistance animal. So before Olivia goes trying to tell people, look, some municipalities have restrictions on certain breeds of animals to even be pets, like the pit bulls, you know. Uh, but if they're a service animal and they're a pit bull, uh, can they still deny them because the municipality denies them? I would say talk to a lawyer. You ain't touching that one with a 10-foot pole. So what are the differences between service animals and assistance animals like we have discussed here? So, yeah.
Oh, sorry. I was about to say that service animals are only tasked to do certain things that requires the owner in something. So perform certain tasks, service animals.
Yes. Yes. That's basically what it is in a nutshell. Are they required to have special training?
I'm assuming yes.
Well, you know what is really assume you make an ass out of you and me. All right, this the old Benny Hill joke. Anyway, you would think that they would, but they don't, because what if the person with the disability can train their own service animal? So they don't need any official service training from an approved trainer or something like that, because that would discriminate against somebody who maybe doesn't have the money to. So you're discriminating against a poor person with a disability who may have the ability to train the service animal themselves. That's the thought process on it anyway. But you know, in the meantime, most people can't train their animals not to pee on the floor in the house, right? How are you going to train them to detect when your blood sugar level is running low and to alert you to that, or to an oncoming seizure? There may be very, very few people out there who could train an animal on how to do that, but I couldn't even tell you how to do it. There may be very few people out there to do it, but because of that, we can't discriminate against them if they can. We have to allow them that. So there is no official training that is needed or certification that they had that training. All you need is a letter from your doctor or therapist saying that you have a need for one. So the service animals can only be dogs, or in some certain circumstances, a miniature horse, and are categorized as animals trained to do a specific task for their owner. The most common example is a guide dog. Service animals are allowed in public accommodations because the owner's need for the service animal at all times. An assistance animal can be trained to perform a task or can be for emotional support. The emotional or physical benefits from the animal living in the home are to qualify the animal as an assistance animal. A letter from a medical doctor or therapist is all that's needed to classify the animal as an assistance animal. An ESA animal can be a cat, dog, or other type of companion. ESA animals do not need to be allowed on planes or in public spaces anymore. They used to, but not anymore. The fact that the term service animal is often used by landlords and public housing authorities to refer to both service dogs and assistance animals is what often creates a confusion. Some examples of assistance animals could be a dog who can detect and alert their companion of oncoming seizures, or alleviate a person's depression or anxiety, or reduce a person's stress-induced pain, or a bird that alerts a hard of hearing companion when somebody has come to the door. Here, I got this little video for you. I snagged from, I think, Instagram or something. Here is a trained service animal notifying their owner that her blood sugar level is dropping. Look at that face. Look at the butcher, butcher, butcher. How could anybody deny that animal? Anyway, here's an example. Look at that face. Oh, isn't it amazing? The animals are amazing. How this animal detected that her blood sugar level is getting low, and then he alerts her by, pushing his snout into her leg. That's why they're usually not little tiny dogs or cats that act as service animals. It's usually a bigger dog like this one. Anyway, I got tons of videos of service animals helping people out, whether it's seizures that they're having or things of that nature. How they could help them go get their medication, all kinds of interesting stuff like that. Hold on, let me see if I got another one of those in this slideshow. No, but I think I do in my notes, which are not open right now. Great. Yeah, I got it on our YouTube page. Let me take a look at our YouTube page real quick. In the meantime, what I'm going to do is I'm going to throw out there the morning attendance poll, which I have not done yet. So let me throw that out for you. So I got an attendance poll out there for you guys.
Yeah, done.
If everybody could answer that attendance poll, please. While I search for a video for something. Okay, thank you. All right, so I found a video that I was looking for. All right, let's take a look really quick at this. Maybe I could insert it in as a slide. Try to do this. Duplicate slide. There we go. And insert link. Insert video. There we go. Hey, I did it. Slideshow. Okay, here it is. All right, so I showed you this video of this service animal alerting the person that their blood sugar is running low. how about this one? Here is another. Here, I'll mute the volume on that because that's probably a copyrighted thing. So let me try to get this playing without the music going. But here's an example of a girl working on her computer in her house, and she's got her service animal there. And she's going to be in danger of having a seizure event, probably because of low blood sugar again. And so the dog's going to help her get to safety to sit down while he goes and gets her medicine for her. As you can see here in this video, she gets up, the dog stops her. It says here, I found out you got a medical condition. Sit down. I'll stay awake. I'll be right back. Then the dog goes and gets her medicine bottle, gives it to her. Then he goes to the refrigerator and gets her a bottle of water. And then lays on her to help her out. These animals are amazing. Okay, so demonstrating that your pet is a service or a assistance animal. You should, once again, it's just providing that letter from your doctor or therapist. We said that about 3 or 4 times again, explaining how your pet is needed to help you cope with this disability or improves its symptoms. Attach a brief personal statement explaining to the landlord that you're just asking for a reasonable accommodation to keep your pet who functions as an assistance or support animal. If your landlord refuses to do that, to provide you with that reasonable accommodation, well, guess what? They're discriminating against you. So now you could file a complaint with HUD, that's the Department of Housing and Urban Development, or at any of the New Jersey attorney offices of the Attorney General, which they also enforce discrimination laws. Okay, so all types of housing, including public housing, are covered by the FHA, except rental dwellings with 3 units or less if the owner occupies one of the units. What else here? A single family home sold or rented by the owner without the use of a broker, or housing owned by private clubs or religious organizations that restrict occupancy in its housing units to their members. Now, service and assistance animals are technically not pets, and owners do not have to pay pet fees or additional rents to have them. The landlord, however, can still charge security deposits for damages. Just don't call it pet security, because then that could create a possible conflict there. Just call it security. It's not advised to call it pet security. In New Jersey, the maximum total security you're allowed to charge is 1.5 times the monthly rental figure. So if you charge 1.5 times a monthly rental figure as security deposit, can you also charge pet security?
Seems like not.
No, whether it's a service animal or not, because the maximum is 1.5 times the monthly rental. If the landlord only charge security deposit, can they charge a pet security as well?
Yes.
Up to 1/2 month. Unless it's a service animal, then you cannot call it pet security. Just charge them 1.5 months security. You follow, brother? Because somebody's going to make a stink about it saying this is not a pet. You're charging me pet security. You cannot charge any additional fees or that for a service animal. All right, so here's on next slide. I'm going to have some questions about the fees for service animals in that NARS or New Jersey Realtors legal diary. So the owner could still seek money from the tenant if there's any damage caused by the animal to the home. Also, if there's a nuisance issue, the landlord does have the right to try to remove the assistance animal through legal proceedings. So get a lawyer. Anybody who has a service animal doesn't mean that they have free reign. They do have to have their service animal under control at all times. You know, if it's chasing after people, trying to bite them and stuff, that's not good. So you can't, you have to, the person who has a disability has to have their service animal under control at all times. So this link here, I already took a screenshot from it and put it on the next page. So here's the question I got from the NAR legal diary. Is it legal to charge a dog, pet, or animal fee when renting an apartment? And it says a landlord may not charge a pet security deposit if it exceeds 1.5 times the monthly rent when combined with the regular security deposit. The maximum security deposit collected by the landlord cannot be more than 1.5 times the monthly rental figure, according to New Jersey statutes 46-8B-21.2. It can be less. Any additional security deposit increase collected annually shall not be greater than 10% of the current security deposit. The security deposit law applies to most residential rental properties, including mobile homes. The exception is an owner-occupied 2 or 3 family dwelling. So you have to have 3 or more rental units available in order to be able to. So can the landlord charge an additional pet fee? Was that slide right there? And the answer is, as long as it does not exceed the 1.5 times monthly rental figure. So, how do fair housing laws apply in real life situations? Here's a real life example. It's going to be a question for you guys to answer. John's been diagnosed with a severe depression and he's disabled as defined by the Fair Housing Act. His doctor prescribes John a dog to help alleviate some of his symptoms. John then asks his landlord if he could have a dog as a reasonable accommodation for his disability. His landlord says yes, but then tells John he needs to pay a $250 pet deposit and must provide proof that the animal's trained. So, did John's landlord correctly handle his request under the Fair Housing Act? And what if John wanted a cat or a ferret instead? What say you?
So I think he's not supposed to say pet deposit, right? Just a regular deposit. But he was already in the apartment, so.
So, what's your answer?
Landlord, I agree with her about not say pet deposit, but 250 deposit. That's where like the landlord messed up.
What if John wanted a cat or ferret instead?
So, as certified only the dogs, so landlord can refuse for cat and ferret.
It can be a horse.
The doctor prescribed only dog.
Well, he also requires that he provide proof that the animal's trained.
Yep, they need proof of training, and
John's landlord did not handle this correctly at all.
yeah, he did not.
The answer is no. John's landlord did not handle this his request correctly. The landlord cannot charge John a pet deposit for his animal because it's not a pet, but rather a service or companion animal required for his disability. Further, the landlord cannot ask for proof that the animal is trained. And lastly, companion animals or ESA animals do not need to be just dogs. They could be other animals such as cats and ferrets or birds. You guys were fixated on the service animals. But remember, in a house, in a residential environment, ESAs can be allowed, and ESAs can be just about any animal. The service
ESA animal is snakes.
The service animals required in public accommodations, that's different. That's a limitation on dogs and miniature horses. And then I got a little warning here. Beware of fake service animal registration websites that may look legitimate, because they provide a lot of links to official websites and resources and such, but they're trying to sell you, we'll register your pet as a service animal. Check this out. Now, this was a couple of years back. This is an old news video before it went back to Congress for them to make some adjustments to emotional support animals and service animals. It's an interesting one. Let me optimize the video for this so that you don't get any skipping, hopefully. Tell me what you think.
The largest airline to crack down on the so-called emotional support animals since that song. The policy change was prompted in part by a passenger who tried to board a United flight with a large peacock on Sunday. Delta announced similar restrictions just last month. CBS News travel editor Peter Greenberg is at United's hub at Newark Liberty International Airport, and that's where that peacock was grounded. Peter, good morning. Most people don't think of peacocks as emotional support animals.
No, but they are. In fact, more and more airlines are reporting that the number as well as the types of emotional support animals is reaching crisis proportions. Now, we're not just talking, as you can imagine, dogs and cats. In fact, the interior cabins of some flights are beginning to resemble Noah's Ark.
I'm not kidding. This woman is wrangling her peacock into the airport.
United Airlines says it warned the peacock's owner 3 times that Dexter would not be allowed to board. The bird lives with an artist in Brooklyn who claimed Dexter was her emotional support animal. In this 2016 interview, she described how she found him.
Now, before this goes any further, she describes how she found him. Okay, to me, this looks like an example of a lady who just got a letter from her doctor, who may have been a friend or whatever, easily got this letter for it to be an emotional support animal. She starts out by explaining how she got this pet as an art project, and then she later got attached to him, so then she got a doctor's letter for having him become an emotional support animal for her. So that's not a legit emotional support animal. That's not the way it works.
I got him originally for an art project, and but then this happened, and I was like, do I have a peacock currently in my neck? Yeah. Yes, I do.
United Airlines already prohibits non-household birds, hedgehogs, ferrets, spiders, sugar gliders, and other exotic animals. Its new policy requires owners to give 48 hours advance notice when flying with a support animal, provide a letter from a mental health professional, and documents from a veterinarian showing the animal is vaccinated and not a threat to the public.
We've had roosters and ducks and pigs and monkeys.
Sarah Nelson is the president of the Association of Flight Attendants and says she applauds the new policy changes.
But what we really need is for the Department of Transportation to act with guidelines for the entire industry.
United saw a 75% spike in comfort animals, from 43,000 in 2016 to 76,000 last year. The critters sometimes relieve themselves in damaged planes. In June, an emotional support dog bit a Delta passenger.
A kangaroo, a pig, a miniature horse. What is that? A goose?
A Delta passenger. Can pigs fly? In 2015, we showed how easy it was to get one on a flight. A Colorado counseling center provided CBS this morning with a letter prescribing the pig as the primary treatment for a psychological disability. Tom Panic, CEO of Guiding Eyes to the Blind, says people are passing off their untrained pets as service animals.
As a person who is blind, my access rights are being infringed upon when somebody passes off a fake service dog.
Now, the new policies for United and Delta kick in on March 1st, and American Airlines is expected to follow suit. But we should note that the new policies only apply to emotional support animals, not the trained, specially dedicated animals that fly for and with people with disabilities. John?
Peter, thanks.
Yeah, people take their pets very seriously. We get it, but you see a lot of people taking advantage of that policy. So I think it's good that they're trying to figure out a way to crack down and make sure that the legit animals go.
Yep, like I said, you give people an inch, they take a mile, trying to take advantage of such things. And that does infringe upon the rights of those who truly need these service animals versus those who just want their pets with them at all times. I have so many videos of this. I wanted to make a class about it, which I still may make a CE class about this topic. There's an instance, well, there's many instances of this, but there was one particular instance where somebody had their service animal with them on a plane, which was a legit service animal for their blood sugar and seizures and all that stuff. And then there was another guy who brought his emotional support animal on the plane, which was a pit bull, and his pit bull attacked the legitimate service animal on the plane, and the person with the disability was, hit that dog trying to get him off of his service animal, and then the owner of that pit bull ended up punching and beating up on the guy with the disability. It's like, so something had to get done. These people getting crazy, taking their animals who are untrained, out of control, and onto planes and public accommodations, biting people, lifting their leg, urinating wherever they are. It got out of hand. So now those ESAs are not allowed in public accommodations. Not required to be. So I put together this little guide here for you. At a glance, you could see the service animals, which are only dogs or in some cases miniature horses, versus emotional support animals, emotional support / assistance animals, which, let's see, public access rights. Only service animals have them, not the ESAs. Air travel rights, only the service animals, no longer the ESAs. Housing rights, hey, that's the field we're talking about getting into right here, right? Both service animals and ESAs have to be allowed. Any special training? Well, service animals do get training, but it's not required to be a special training by a certified trainer or anything like that. Whereas emotional support animals, they don't need any kind of training to perform some act. They could be simply there for their emotional support. Do they need to be registered or certified? No, neither service animals or ESAs need any certification, so to speak. And you can see I put a little notation down here. Trained means task trained for a specific disability, which goes well above and beyond the basic socialization and obedience training. Okay, but there's no official training that needs to go underway there. Okay, so
this also looks like a big hypocrisy. We have lots of rules, lots of policies to save and support and keep animal with peoples. Same time, we have it's 90% things is depends on to kill the animals and eat the animals.
Well, killing and eating a dog.
At the same time, pig, cow, goats, those all are all the service and emotional animals.
Okay, we're not going to go down that rabbit hole.
Yeah.
I'm not taking the bait on that one. All right. Okay, let's get past the service animals now. Because you just need to know the basics. When in housing as a real estate professional, somebody says that they have a pet. In order to allow pets, landlords can deny them. They can have no pets policies, etc. If the landlord does allow pets, they should. We do have pet riders and such to be added to lease and sales or lease contracts anyway. That basically say that the animal should have had their distemper shots, their rabies shots. All their shots are up to date. And they don't pose a threat to anybody, and they should have some sort of a letter from your veterinarian. That's the requirements that we could do to try to protect our landlords that we represent anyway. When they say that they have a service animal, however, what do we need to get from them?
The doctor prescriptions.
Just a letter from their doctor, or it's on the official doctor's letterhead stating they have a medical need for this animal, and then the landlord cannot deny them.
So I have a question. So you said that some people will like get their pet like not certified, like as a service dog or animal, right? How can you prove that? Do you call like the doctor's office or?
Yeah, you call your doctor and your doctor or therapist, and you ask for a prescription for your pet to be a service animal.
I mean, like me as a landlord, how can I prove that that's an actual like?
It has to be on the official doctor's letterhead with their contact information. So you could also call up that doctor and say, "Hey, listen, I got this letter from this person on your letterhead prescribing a service animal. I'm just calling to confirm that this is legitimate."
Oh, okay. Thank you.
That's why it has to have the contact.
So even if that prescription has any dates, means that this 1 year old or 5 year old or 10-year-old.
You can request a new one each year because, hey, when your doctor prescribes you pills, right? They're only good for so long, right? You got to get a new prescription for another one. Same thing with them. You get those prescriptions for the service animal each year because you may not need it permanently. So yes, you can ask for that because it could have been a one-off that they got a doctor friend to sign a letter, and you want to get a new one each year, that's fine. Okay, so fair housing. We have the Equal Housing Opportunity poster. So the Federal Fair Housing Act of 1968 instituted the use of an Equal Housing Opportunity poster. It's got that picture of a house with the equal sign in the center of it. I'll show you what it looks like in a moment, which can be obtained from the Department of Housing and Urban Development, HUD. It features the Equal Housing Opportunity slogan, an equal housing statement pledging adherence to Fair Housing Act, the support of affirmative marketing and advertising programs, and the Equal Housing Opportunity logo. When HUD investigates a broker for discriminatory practices, it considers failure to display this poster evidence of discrimination. Wow. So if somebody accuses you of discrimination and they send a HUD investigator to your office to investigate, the investigator will first look around your office to see if they see the Equal Housing Opportunity poster somewhere, which is required. Anytime someone's offering housing or housing services, they have to display this poster. If it is not displayed anywhere in your office, they stop their investigation. They don't need to ask any questions because that serves as evidence that you engage in discriminatory practices if you do not advertise that you offer equal housing opportunity. Wow. So the threshold of the requirement for being found guilty of discrimination is pretty low, isn't it? Now, towards the end of this chapter, like on the last page, there's I just put this here. You don't got to turn there now, but I put this statement there so that you can see that backs that up. The complainant does not have to prove guilty knowledge or specific intent to be found guilty of discrimination. Only the fact that discrimination had occurred. That's all that someone needs to prove a discrimination case. Not that it was your intent to discriminate. You could have had honorable intentions. But if the end result was that someone was still discriminated against, you're guilty of discrimination, no matter your reasoning for doing what you were doing. You'll see what I mean when we talk about steering. You know, some people steering, it could have been for honorable reasons. I wasn't trying to steer you in an area to segregate you. I was trying to put you in a better area, you know. Doesn't matter. When you're the one that's making the decision where somebody should live, you know, that can be construed as discrimination. So, regardless of your intent. Okay, everybody got these highlights?
Yes.
So do you need to have this equal housing opportunity sign up in a property?
If it's like a model home or something, not on a property. Anybody who's offering housing or housing services, like an apartment complex or a builder who's offering to sell housing, and they have model homes there for you to come take a look at and to meet up with them. Yeah, in those instances, you need to have the equal housing opportunity poster displayed. Okay. Okay. So this is the equal housing opportunity poster. This is what it looks like. And failure to display this poster is evidence of discrimination. Pretty low threshold to be found guilty of discrimination, I would say. Simply not having a poster. So if you get mad at your brokers and you leave that office, don't start claiming discrimination and ripping the sign off the wall. That would suck. All right. Blockbusting and steering. Blockbusting and steering. So we already went over blockbusting, but here we'll highlight it in the book. So let's take care of these highlights, and then we'll move on to the next slide, which I have that actually I think has better definitions here. I don't like the book's definition of steering because it assumes that everybody's a racist. You just don't know it. You have an unconscious bias. You are unconsciously discriminating against people. That's nonsense. That's something people with an agenda trying to push discrimination and victimhood everywhere. That's the kind of arguments that they make. I despise that. You have people out there who don't discriminate. You have people out there that try to believe that everybody is, or that believe that everybody's equal and try to make things equal for everybody. So that slur against people that because you're a different race or something, because you're white, you're discriminating against somebody, even though you may be unaware of it. Even though you may be married to somebody of a different race, you still have a bias and you're still engaging in discrimination. That's too much of a leap for me to accept there. All right, so let me know when you guys got those highlights.
Yeah, got it.
I'm good.
Done.
Okay, everybody got it?
I'm good as well.
Okay.
Yes.
So the Fair Housing Act of 1968 makes these practices illegal. Although they're not mentioned by name in the law, it does make these practices illegal. Blockbusting, sometimes called panic peddling, is using discrimination as the tool. This is my definition, the way I define it. The book's definition is kind of confusing, the ones that they got there. This one's a little bit more descriptive of what actually is happening. Blockbusting is sometimes called panic peddling. It's using discrimination as the tool to play on a homeowner's fears of a protected class, that these people are moving into the neighborhood in order to scare them into selling. Steering, so blockbusting is discriminating against who?
Discriminating against the homeowner?
Yes. It's discriminating against the homeowner because it's using discrimination as the tool to try to scare them into selling their home, basically, in a nutshell. That's why it's also known as panic peddling. You need to know that for exams, that blockbusting is also known as panic peddling, okay? And it's discriminating against the homeowner. Whereas steering, who do you steer around in a car in the real estate business? Who are you driving around and steering in a car?
The client?
What kind of client, though? Who do you drive around? What kind of client are you driving around? Buyers and renters, right? Because you're driving them around to different properties. You're steering. You're the one behind the wheel. You're not driving around a homeowner. You drive to their home and that's it. You drive around the buyers and the renters. So steering would be discrimination against buyers or renters. And steering is limiting someone's options of where they can live by not showing them all the properties that meet their criteria in the areas that they're looking. By channeling those home seekers to or away from certain areas, or simply not making them aware that homes are available in those areas that meet their criteria. Now, when the agent is the one who decides where a buyer should live, that could be deemed a discriminatory act, even if your intentions were honorable because you were filtering out properties, trying to get rid of the crap ones and the crap areas and all that. Who are you to say what a crap area is? Isn't that all kind of objective, I guess? Look, I remember I had a girl walk into my office once in Edison. She lived in Newark. She worked in Edison. She she came to my office to look for a new place because her lease was expiring and she didn't want to renew there. She needed to find another place. So she comes into the office and I pull her in the back and we go to one of the computers and I searched the MLS. I put in a search criteria right there with her sitting right next to me. And we're searching through the homes and many properties came back in her price range, meeting her criteria. So we started filtering through them. And, some of them we were like, those rooms are small. She's like, no, that's not small. Take a look. And I went back to it. And I was like, yeah, it is. Look, I'm familiar with these pictures. Look at the angle that they took it and everything. And then she started to trust me after that, that, yeah, you're right. The angle of that room is kind of small based on the picture. I was like, yeah, I know. I could spot these things a mile away, based on the trickery of the camera position and stuff. So we're building this rapport and we're going through these properties, we're like, yeah, no, that one's not a good area. Oh, okay, that one's okay. Yeah, that one looks pretty good. Let's put that on the list. So I'm going through these properties because there's so many of them. And she's like, oh, wait, go back on that one. I was like, okay. I was like, oh, yeah, this one's not bad. Let me see. Price is good. Let's look at the pictures. Oh yeah, these room sizes are big. Oh yeah, this is pretty good. Not bad. Let me pull up the map and see where it is. And it was like, ooh, that's a pretty rough area. Because at the time I was doing some property management with people, and I was familiar with the streets in Newark and the higher numbers and lower numbers and the different streets, you know, and the areas. Okay, so I was kind of familiar with it at the time. And so I was like, ooh, that's a pretty rough area. These are the words that came out of her mouth. This was her reaction. This is exactly how she said it. She was like, "Now, nobody got shot there in at least a year." I was like, someone got shot? You know? So we're clearly living in two different planets of what we consider a good area. You know, she's like, nobody got shot there in at least a year, so that's a good area. And I'm like, somebody got shot? You know? So we're clearly living in two different planets. So, but it's not up to me to decide because she's the one that got to live there. You know, so if I'm trying, if I tried pushing it, or if she had a chip on her shoulder, she could be like, "Oh, he's trying to steer me away from that area," you know, and file a complaint against me, you know. But she saw I was trying to help her, and I was working with her, and we built this rapport. So she, you know, she didn't do nothing like that. But this was a good example of showing how perspectives can be greatly different of what is a good area. To her, a good area is someone didn't get shot in the last year. Now, that may be good compared to where she currently lives. You know, where you could have gangbangers shooting each other every day. You know, I don't know. But that's up to her to decide, not me. So I didn't sit there arguing with her over it. I'll show her whatever property she wanted to see. As long as I don't get killed showing it. All right, so redlining is refusing to give financing or mortgage loans or insurance policies even though a person can afford it as a means of discrimination. See, do I have this in the notes? No. Yes, I do. All right. Here's where the term redlining comes from. I'm going to show you guys a video here that was pulled from a documentary about the civil rights movements and stuff, and redlining and blockbusting, and actually this is it was about a lot of different topics, but this video clip here is about specifically about redlining. So without further ado, let's get her started. Let me optimize it and go.
In the 1930s, in the wake of the Great Depression, FDR is president. He wants to bring economic relief to millions of Americans through a collection of federal programs and projects called the New Deal. One part of that New Deal was the National Housing Act of 1934, which introduced ideas like the 30-year mortgage and low fixed interest rates. So now you have...
Wow, let's just stop there for 1 second. You guys see those that sign? Let me back it up a little bit. Brand new home here. This is a mobile home. $3,800, $960 cash down, and $27.62 a month mortgage payment. What happened since then? Now, in some houses, that's your monthly mortgage payment, the whole price of the house back then.
In the 1930s, in the wake of the Great Depression, FDR is president. He wants to bring economic relief to millions of Americans through a collection of federal programs and projects called the New Deal. One part of that New Deal was the National Housing Act of 1934, which introduced ideas like the 30-year mortgage and low fixed interest rates. So now you have all these lower income people who can afford homes. But how do you make sure they don't default on their new mortgages? Enter the Homeowners Loan Corporation. the HOLC created residential security maps. And these maps, they're where the term redlining comes from. Green meant best area, best people, aka businessmen. Blue meant good people, like white-collar families. Yellow meant a declining area with working-class families. And red meant detrimental influences, hazardous, like foreign-born people, low-class whites, and most significantly, Negroes. Again and again on these HOLC maps, one of the most consistent criteria for redline neighborhoods is the presence of Black and brown people. Let's be clear. Studies show that people who lived in redlined areas were not necessarily more likely to default on their mortgages, but redlining made it difficult, if not impossible, to buy or refinance.
All right, so that's where the term redlining comes from. These residential security maps. So, I mean, if we were to look at it, even back then, I would be discriminated, because if you see on that same line over there, it wasn't just Black people they were talking about. They were also talking about foreign-born and foreign people. Well, actually, I was born here, but my parents weren't. So they would have been discriminated against for being Polish, you know. And if there were the working class, that would be in the yellow area, right? Or foreign-born citizens would be in the red-lined area, where they would more likely be denied loans or insurance policies. So we're so familiar with Black people being discriminated against, people of color, but it did cover a lot of people were getting discriminated against back then. You know, we went over before women were getting discriminated against for even years after this. So there was a lot of discrimination that was going on in the past, in our early ages of our country and building up, even up to the 70s and, you know, even the 80s and 90s now, as we're adding more protected classes to these laws. But it's an interesting thing. Anybody ever hear of these red line maps before?
Yeah, I remember learning that when I was younger.
I've heard redlining as well.
Yeah, I mean, you can look up, there's actually, I had a link somewhere. I used to have it here in the slideshow, where, but you could do a Google search, and there's archives where you could look, do a Google search for redline maps in your town. And you may be able to find some in an archive still. And you could see if there were areas of the town that were, where they have these HOLC maps, the redline maps in archives online. Keep in mind, they are very, very, very large files, though, because they're high definition maps that you zoom in on. But okay. So disparate impact and disparate treatments. This is this can be a legitimate argument. However, it can also be used to stretch an argument further than it really needs to be as well. And they'll justify, this is often justified by some activists to try to make everything into a discriminatory act. By showing you something that we get everybody nodding their heads to in agreement along with, and then it starts putting some information out there that kind of stretches it a bit. In the last couple of years in our country, we've been seeing, it seems like everything is discrimination. Everything is discriminatory. Everything is racist. More than we've seen in the past. Where did this explosion of everything being racist come from? And I could trace it back to a worker that was assigned by President Obama, of all people, to work in HUD, the Department of Housing and Urban Development. The guy created a report. He basically took the statistics of how many people are in prison, and then he segregated them solely by their races. And he did a head count, and he said, well, there's more Black and brown people in prison than there are white people. So therefore, the system is systemically racist. That's quite a leap to take. It does not take into account that the people actually in prison actually created the crimes, actually did the crimes that they were convicted for. It just does a head count based on people's race. And then, so it is, I don't even want to call it a flawed study. It's not even a study. The guy just created a report. And then based on that report, somebody did a study using that report as their basis and evidence. And then since then, we've had politicians referencing these documents as the basis for their evidence of systemic racism in our criminal justice system and in policing and in everything. So now we have all of this arguments against that stuff, and now President Obama was involved in a lot of these things where this started. So it wasn't that long ago. Now, let's give him the benefit of the doubt. I'm not going to say he's a race baiter or anything like that. I'm going to say he had honorable intentions to do this, but maybe a little bit misguided in how they went about it, because this took off in a totally different direction now. He went as far as getting HUD, information from HUD, information from the FHA, and information from the Census Bureau. And he spent millions of dollars for them to create these maps. And for lack of a better term, I'll just say that they were race maps, because it would put like white people, the population of white people in a certain area were maybe like a blue dot, and maybe Asian people were a red dot, and black people were another colored dot, and so on and so forth for different races. And he actually had a speech that he had at the caucus of, it was, what do they call it? The Black Caucus of, I forget what the hell it was. But he had HUD, the FHA, and the Black Congressional Caucus there. And he did a meeting and he said, "This is my plan. We put together these maps, and anybody who's working in the housing industry, offering real estate agents or mortgage companies or mortgage reps or insurance brokers, before you sell somebody a house, before you consider selling somebody a house or giving them financing or insurance, you've got to look at our map first." So each person of a different race is a different color on that map. And when you're zoomed in, you could see that there's larger populations of these people or those people there. But if you zoom out on that map for that area, what we want to see is a nice purple. That's a nice mix of people. So if you zoom in and if you zoom out and you see a large concentration still of one particular dominant color there, he's like, you better not be selling them a home or giving insurance or whatever there. And now the reasoning behind this was integration. I guess it's going too slow over the years for him as our country's progressing over the years. However, what have I been teaching you guys so far pertaining to discrimination? You're supposed to be colorblind. You're not supposed to look at these things. All of these laws that we went over, all these federal laws so far, have been showing us that you do not look at a person's race. You do not treat people differently because of that. You cannot be the determiner of where someone should live. That's called steering, and that itself is a discriminatory act. However, the president himself was telling agents that if you don't do this, then you're going to be in trouble. We're not going to be giving any government insured or backed loans or insurance policies or any of this stuff. And when I saw this going down, I was wondering how this is going to affect the real estate industry, and how is this just going to affect the country? I understand what he was trying to do. It was well-intentioned. It was trying to be, once again, for a lack of a better term, forced integration, okay, to get people to integrate quicker. But you cannot be the decider of where somebody lives. You got to leave it up to them. I'm going to give an example of this. I once had this Hispanic gentleman. He was buying a house in Elizabeth, and it was a new 2-family house down the Port Elizabeth. And it was in an area that there was a lot of gangs in and a lot of activity. Okay, let's just leave it at that. But it was a brand new home, you know. And the guy, he was a hard worker. He had several jobs, and he saved up $200,000 cash. And he wanted to buy this new 2-family home for, I think it was like $610,000 down Port Elizabeth. And I could see the future here that this house is not going to keep its value, you know. And so I suggested to him, I was like, you know, if you got that much money to put down, you want to buy a house in this price range, I could get you a house in Westfield for that kind of money. And he was like, no. My people here, they speak my language, my English not too good. He's like, my church here, my food, you know. And it's like, enough said. You know, I didn't want to push him on the topic. I tried guiding him a little bit, but I could have been accused of steering there, because when you're the one that's trying to push them in a different direction, you know, it could be deemed discriminatory, even though that was not my intent. But remember, intent is irrelevant when it comes to discrimination. If you're the one deciding where someone should live, that is steering. That is defined as steering in the federal law as discrimination. So once he started like explaining, I was like, no, stop. You don't need to explain to me. Sorry I brought it up. You know, I mean, I really saw what was going on. And he did buy the house. Okay, time goes by. A little time goes by. The real estate market takes a slump. And it starts crashing. And he contacts me. He wants to sell the house because the prices are falling so crazy and he's scared. And I was like, listen, you got the house. Did you lose your job or something? You can't afford to make the payments. I was like, don't bail out of it. That's like buying stock high and selling it low. That you don't do that, you know. So you don't panic and get scared because the stock is taking a dip. Same thing with the housing market. If the real estate market takes a dip, you don't bail out of it, you know, because you don't actually realize a loss until you actually sell and cash out and sell at a loss. I said, at this point, you'd be losing a lot of money. You put $200,000 cash down, and right off the bat, I'm telling you, I just did a lookup of the property values. You already lost $200,000 in equity in that property if you sell today. You know, so I suggest that if you don't have to sell, don't. Real estate markets are cyclical. They have bouncing points. They go up, they go down, you know. And so he was like, no, I want to sell. I was like, okay. I was like, but in this case, at this point, it's probably going to be a short sale because you owe more to the bank than your home is currently worth now. So you're going to lose that total $200,000 that you put in, and you may end up owing money to the bank still. If we do a short sale, we could try to negotiate with your bank not to pay them anything, but you're going to be selling at a loss. So he agreed. And so we put it on the market, trying to sell it. Couldn't get any bites because the values were going down and not as many buyers out there. We ended up cutting the price of the property almost in half. And that's where we started getting bites and people calling up to make appointments. But when that happened, something weird happened. Apparently, I guess one of these gangbangers or whatever, what they did is they threw a Moftail cocktail. It's basically a homemade bomb with gasoline in a glass bottle into a car that was parked in the street in front of his house. And they basically blew up a car in front of his house. So when the appointment came for the showing, I was showing his house, and I went to the house, and I was there early, and I was just like, oh my God. It looks like some of these war scenes that you see on the news where a car exploded and all you see is like the black charring in the street and on the grass. And I was like, what timing? You know, the guy's trying to sell his house and then this happens. And so when the buyers came, they asked what happened there, and I can't lie, you got to be truthful and honest with them. I was like, well, somebody blew up a car in front of the house. They threw a Molotov cocktail there, and they blew up a car in front of the house. It was a car fire. And needless to say, they weren't interested in buying there no more. So I went back to the guy. I said, listen, this is a sign for you. You're not meant to sell right now. Keep the house, hold on to it, you know. And he did. And the real estate market was down for a couple of years, but eventually it bounced back and he got his value back, and then he sold out. Okay. But that's just an example of where you could be accused of steering, and discrimination, even though it's the furthest thing from your mind.
Well, overall, Victor, it looks like agent job is not easy. Realtor job is not easy.
It's interesting. Experiences that I had.
You see the car is blasting in front of you.
The guy's left a car getting blown up in front of a guy's house. I've had somebody who was trying to flip the house, and they hired a worker, which was a relative of the former owner who refused to leave unless the new owner, who was going to be fixing up the house, allowed him to work there and get paid to do the gutting of the house and do some basic work. And then he agreed that he would leave. And then I eventually went to the house to check on the progress of it. And I found the guy dead in the bathroom from shooting up. Shooting up drugs, and I couldn't open up the bathroom door because he was sitting on the toilet and his foot was stretched out against the door. So I pushed in with the arm, and I looked in, and I was like, oh my God. And so I had to call the police, and, these are the kinds of things. From that to being chased by a deaf dog in somebody's house, to walking in and people doing the deed, in the bedroom when you're showing a house, people being intimate. I've come across all kinds of crazy, wacky situations in this business since being in it in 2004. It's kind of crazy, really, but it's an experience. It's an experience, that's for sure. Okay, now disparate impact, sometimes referenced as disparate treatment or adverse impact, is a policy or practice that seems to be neutral, but in fact may disproportionately impact certain groups of people. This results in, or I shouldn't say this results in, I should say this could result in discriminatory practices, resulting in unequal treatment and hindering equal access. For example, a lender or property management company may require full-time employment for the renter. On the surface, this requirement seems fair. However, it discriminates against someone who's receiving public assistance or disability payments and may not work. Okay, we can understand that one. But you got to have common sense too. Common sense just goes out the window, and you consider everything disparate impact. The Department of Housing and Urban Development enforces the Fair Housing Act of 1968, and they published guidance that explains that the use of criminal history to exclude people from housing may violate prohibitions in certain circumstances. Okay, once again, this is stuff that's rooting back from that story I told you about Obama appointing this guy to work for HUD. And then he created this report. And then someone else within the same department then created a study based on that report from a certain perspective that they wanted to show. So housing providers may not use criminal history as a pretext for intentionally discriminating. 100% agree, because that is racist. In other words, you can't require a criminal background check on a black person, but not a white person. That is outright discriminatory. You should do if you're going to do criminal background checks, you do them across the board. But the interesting thing is now they say that if you do criminal background checks across the board, you could still be discriminating, and because the criminal justice system is biased or has a disparate impact. So housing providers may not use that criminal history as a pretext for intentionally discriminating based on race or national origin. Applying a criminal background based on restrictions against a protected class different than they apply to a non-protected housing applicant. In other words, doing a criminal background check on a black person, but not a white person. Which I agree, that is outright racist and that should not be allowed. But do you believe that it should be allowed, that you should be able to do criminal background checks on people? If you're a landlord?
Yes.
Yes. Yes, definitely one.
Didn't we discuss that you're not allowed to until after they?
Yeah, I mean,
We give them
guys are all being so racist wanting to do criminal background checks. Now you may be saying, how the heck are racist doing a criminal background check? We're looking for people who have committed crimes. Well, wait a minute. Didn't you just hear the whole story I told you about there not being an equal number of people in prison that are white versus black? So therefore, the criminal justice system is racist. And therefore, if you're relying on criminal background checks, that by extension makes you racist. Really, this is the law now. This is the law now in New Jersey, and that's the leaps that they took to come to that conclusion. And you could thank our politicians for this. Why? Because they have an agenda. They're always trying to appease people to vote for them, and that they're for them, and that they like to first turn people into victims instead of supporting them and encouraging them. Instead of that, they like to promote victimhood, and then how that they're the great white hope, that's going to come to your rescue if you vote them into office, so to speak, So, for example, a management company with the intent of keeping all tenants safe might reject an applicant based on an unspecified criminal history. This ignores groups who are incarcerated at higher rates. There you go. Than the general population, and may not result in a safer environment. But then again, it may. Yet another example of a zero tolerance for violence. Now, this one's taking a leap. It does not take into consideration common sense. Another example is a zero tolerance for violence without recognizing that perhaps up to 25% of women have experienced domestic assault. So this policy could negatively impact them. Why? They're the victim. Zero tolerance for domestic assault. You're not blaming the victim, are you? That's the picture they're trying to paint here. But if you enter common sense, this is the person that was assaulted. We could see the police reports and such. So if you see, they wouldn't have a criminal record for being assaulted. So how would somebody even get that knowledge, let alone not rent to you because you are part of a violent domestic assault? Let's look at the court papers. Oh, you were the one assaulted. Okay, well, you're the victim. We're not going to hold that against you. But the picture they're trying to paint here is that it could be. Okay. See, this is why that disparate impact treatment, they say this results in discriminatory practices. No, it does not. It could result in discriminatory practices if you don't use common sense. So New Jersey passed something called the Fair Chance in Housing Act, the FCHA, beginning January 1st, 2022. The New Jersey Fair Chance in Housing Act. Did anybody ever hear of this one? It prohibits landlords from generally asking about criminal history on housing applications. In most cases, landlords are prohibited from running criminal background checks on an applicant until you first make a conditional offer to rent to them. So I got to rent to you before I tell you that we're going to do a criminal background check. And then when I approve you, I have to say, well, this approval is now contingent upon me doing a criminal background check after the fact. Why? Well, politicians are slick in doing this because you already agreed to rent to them. Now you need a good reason to back out of it. And they make it very hard to. They make it hard to understand in what instances you can deny somebody based on their criminal history too. So the best we could do with contradictory guidance. Now, this is my 2 cents here. This is not from the book or legal or anything. This is just my 2 cents. The best we could do with contradictory guidance like this is to be a good person, treat everybody equally, fair, and just. Hopefully, you're not going to get sued in the process. Sometimes politicians, in the name of fair housing and something that they call equity is not equality, are justifying a systemic racism claim by absolving individuals of personal responsibility and accountability for their own actions, for the crimes that they've committed. Instead, judging individuals based on the racial groups that they fall into as the reason to excuse them for committing their crimes. You see this all over the country now, right? Take a look at California, right? You don't arrest people if they steal from your store, but they stole less than $900 worth of goods. It's not considered a crime. This is why Walmarts are closing in these areas now. If you guys are seeing all of the Walmarts that are closing in these areas, that are getting robbed constantly, people walk in there with shopping carts and big black bags, garbage bags, that they just walk up and fill their bags up and then push their way out the store without paying for stuff. And hey, you say, hey, people got to eat, people got to live. That's their excuse for allowing them to rob a TV or other things of that nature. That's as long as it's under $900, right? So law-abiding citizens wanting to safeguard their family, property, and tenants have a responsibility to do so, but they could be found guilty of discrimination for denying renters who have a criminal history. It sounds crazy, but that's now the law in New Jersey. Okay, so these are my words put into common sense. You guys can agree with them or you could disagree with them. Either way, this is the law now and we need to follow it.
Yeah, I totally agree.
Which, if you're a landlord, a residential landlord in New Jersey and some of these other states, I don't know if I would want to do that. I think I'd want to just fix and flip a house to sell it. I don't think I'd want to rent a house in New Jersey because of all of these crazy guidelines that they put into place now. And the weird part is that you could be held liable if you don't safeguard your tenants. But yet you can't do criminal background checks. And if you do criminal background checks, in most cases, you can't deny people because that would be a racist thing for you to do. Even if the person's the same race as you, it doesn't matter that because you're relying on that criminal justice system, which is systemically racist. At least that's the argument that they're giving. I know you're chuckling about it, but it's what else can you do, right? You chuckle, it's ridiculous, but that's the law now. So here, let's listen to this non-attorney try to explain it. And it's interesting. She does it with a straight face. I guess she's reading it from the script, so she's doing it with a straight face. But listen to the words she's actually saying. She's talking about people doing they have a neutral policy on doing background checks on people, but yet you could still be found guilty of discrimination. It's the craziest thing. Let's watch this.
Welcome to Window to the Law. I am Mame Nyamiche, staff attorney at the National Association of Realtors. In this episode, I will discuss why it is important to give your criminal background screening practices a second look in order to avoid a fair housing violation. In fact, several housing providers have found themselves faced with lawsuits alleging the misuse of criminal history in violation of fair housing laws. In New York, a housing provider recently settled a case for over $1 million, where the plaintiff alleged that the housing provider maintained an overly broad ban on renting to people with criminal records. In Florida, as many as 48 Florida housing providers were also sued for the alleged improper criminal background screening of prospective tenants.
All right, let's stop here for a second. She's throwing around all kinds of basis for this legislation by saying people were sued. People did a settlement. It doesn't say that anybody was actually found guilty of doing any kind of discrimination. It's just saying that these people were sued, alleging this, alleging that. It's not saying that any discrimination actually occurred.
The use of criminal histories to make housing decisions has long been on the fair housing advocates' radars. In 2016, HUD issued guidance urging housing providers to exercise caution when implementing criminal history policies and practices to make housing decisions. In the guidance, HUD reported that African Americans and Hispanics are arrested, convicted, and incarcerated at disproportionate rates compared to the general population, resulting in criminal history-based barriers to housing and creating a disproportionate impact on minorities. While persons with criminal records are not a protected class under the Fair Housing Act, race, color, and national origin are, and the improper use of criminal history to make housing decisions may have a disparate impact on those protected classes. Under a disparate impact analysis, a housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
Say what? I think you guys were paying attention to that. Let me back it up and you can listen to her words again.
Have a disparate impact on those protected classes. Under a disparate impact analysis, a housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
That's crazy.
Yeah, they're saying the criminal is not as protected. But if you are on the criminal basis, if you are not giving, then you are against the protected class.
Yeah, residential landlord. I would rather just fix and flip houses or build them and sell them or do something like that. You know, it's insane.
Meaning, liability may arise when a facially neutral policy or practice has or predictably would result in a disproportionately negative impact on a protected class under the Fair Housing Act. Some states and localities, such as Illinois, New Jersey, and the District of Columbia, have even enacted laws restricting a housing provider's use of criminal records. Consider these best practices when using criminal history to make housing decisions. Have a written criminal history policy. Apply criminal record policies consistently. Do not ask or consider arrests without convictions. Avoid blanket bans on applicants with a criminal conviction. Be sure to exclude only those with convictions that present a demonstrable risk to resident safety or property. Document housing decisions. And become familiar with local and state laws that apply to a housing provider's use of criminal histories. For more information on use of criminal history,
that's something, isn't it? What else can I say? Yeah. Oh boy, oh boy, oh boy. Let me grab something from this slide.
Yeah. Now I'm remembering the few months back, one of my friend, his realtor, I was looking for investment house. And he said, if you're looking for rent, then don't buy house for rent.
Yeah.
And I didn't ask too much. And he said, if you're thinking to buying a house and then rent, don't think about that.
Yeah. It's really involved, at least in New Jersey.
Yeah, New Jersey.
New Jersey, Illinois, and Was it,
Yep. That's why I purchased house in Virginia.
Yeah. Well, yeah, Virginia's kind of up there as well.
Yes.
Maybe not as bad, but they're kind of out there as well.
Yes. Yes.
But it's unfortunate what's happening right now. And for me, I think this is setting back all of these civil rights legislation and movements that have occurred in the past, because now you're considering criminals a protected class and you're trying to excuse it based on race. It's like, listen, I don't care if you're black, white, or any other color. If you committed a crime, you deserve to be in prison. What's the argument here? I think now we're going to do a headcount because there's not an equal number of criminals based on their race in jail. Sure, you can make an argument. Well, yeah, cops picked on black people more, so more of them are incarcerated, even though there's probably an equal number of white criminals out there. Okay, so now we have to make up for that by excusing some of the criminal activity. That's not the way that you do it. Start arresting more criminals across the board that are white then, as well as the black ones and other colors. It's kind of a ridiculous argument that politicians have been making. And if you guys seen, this all stemmed from a 2016 report from HUD, but that report is based on an even earlier report from that guy who did the head count of the number of people in the prisons. I told you during the Obama term. So he did some. You figure the great uniter. That's what he was billed as. He's done a lot of stuff that's, as we see over time, it's actually dividing us more. I think. That's my 2 cents. Let me move on. I don't want to. Boy, oh boy. Okay, I love this case. This is a good example to show you about the laws that I've been teaching you, about the protected classes, and how real estate agents should act. And this is a good example here. This is an older news story. This is like in South Carolina, or one of the Carolinas, I think, where a real estate agent was caught discriminating. Now, how was she caught? Well, the news guy who's created this news story was shopping for a home. He was getting married. He's a white guy who's getting married to a black woman. They don't say all this. I did some research on it and I found out the details of this story. But he's a white guy. That's the reporter. He was getting married to a black woman. His college roommate was a black guy. That was his best friend. And he got him in on this investigation as well, just to give you a little background of what's going on here. So he went shopping for a home, and he went looking in this condo, and this one real estate agent, she was always the agent that would show homes whether they were listed or not. And he went initially on his own without his fiance. And she was espousing some discriminatory language. So he got the feeling that she's not new to this, and she's been doing this. So he started sending people in, singles, couples of different races, etc., to see what her reaction would be, and to get it all on camera. And you're about to see this. This real estate agent talking about things she has no business to be talking about. She's being racist, and then they show that they report it to HUD, and then what the outcome of the case, what the outcome of everything is. So it's an interesting case. Let's take a look. Let me optimize the videos and stop mine so we don't get as much sputtering. Here we go.
High rise in Columbia. No African Americans living there. Is there a reason? Good evening and thanks for being with us. I'm J.R. Berry.
And I'm Darcy Strickland. The reason could lie with one real estate agent. A News 19 investigation uncovered what appears to be active discrimination inside a prominent Columbia high-rise.
News 19's Johnny Chappell has been working on this story for months now, and he joins us with the details.
A lot of us here have put a lot of work into this story, and we hope that we can bring some possible good out of it, J.R. and Darcy. Who has the right to tell you where you can live? In January, I started looking to buy a new home. The very first place I visited, a realtor told me that for 25 years, the building had remained exclusively white. Her comment sparked our investigation, and our investigation has the federal government looking to take action. Looking up from anywhere between 5 Points and downtown, it's hard to miss. 1829 Senate Street, a 30-year-old high-rise, 19 stories of high-end housing. In all, 96 luxury condos. The Heritage, all white on the outside, and there's a woman who may be trying to keep it all white on the inside.
We do not have a mixed neighborhood here.
Ann Bryant is a longtime Heritage resident. She's also a realtor, and she shows just about every property that comes up for sale in the building. After my experience, we sent a team to investigate.
You get 7, that's good. I'm going to take you to see my son's unit first. Okay.
A News 19 employee and her sister told Bryant they wanted to see what was available. Bryant showed them 2 occupied condos before going inside a condo for sale on the 12th floor. At the time, the residence was not on the market. Bryant said she thought it would list for around $170,000.
When I have a listing anymore, I may not even put it in the computer because it's just... they go like that.
All right, let's stop right there for a second. She said when she gets a listing, she don't even put it in the computer because they go like that. When you get a listing, how soon do you got to put it in the computer, the MLS?
Within 48 hours.
Within 48 hours. So right off the bat, there's one law she's violating.
Yeah.
Because it's just, they go like that.
And she said that all prospective clients and their realtors go through her.
I meet people to show in the building. If it's another agent showing, I meet them.
Bryant went on to indicate that race determines whether she allows a person to see or inquire about purchasing property.
And I'm very careful when I make this statement. We do not have a mixed neighborhood here. And I think that is because we try to be careful and we try to not that nobody dislikes them. I work with them all the time. It's just that they tend to. I'm talking too much. They make a neighborhood go down because they don't take care of it yards. They just take different.
She makes those differences appear black and white.
We do have some Orientals in one of the penthouses. Been here for years, nice as they can be.
Those statements marked the 3rd time we had heard Bryant referring to possible discrimination. She said it to me during my visit and to another News 19 employee during a previous trip. We showed the tape to Dudley Gregory, who's with the U.S. Department of Housing and Urban Development.
That conversation is enough to give me pause and that I would want to look further.
Gregory said Bryant's behavior very likely violates a federal law. Under the Fair Housing Act, a realtor cannot discriminate in 7 protected areas, including race.
The issue is how many people have been to that place that are minorities that have been denied to even come through the door.
Local realtor Shelby King says those licensed in her field must complete class time every 2 years to keep up to date on the Fair Housing Act.
We are reminded about fair housing constantly.
King cites standard clauses in buyers and sellers agreements that deal with the law. She says there are certain things a realtor cannot discuss when showing a property, and that sometimes she's had to steer clear of a client's questions.
And they will usually preface the statement with, I'm not prejudiced, but what's the mix of the neighborhood? And I cannot address that.
So why would Ann Bryant, who's required by her profession to adhere to a federal law, risk losing her license? She agreed to meet us at the Heritage for an interview. You said you show most of the properties here. To the best of your knowledge, have you ever discriminated based on a person's race as to whether or not they can live here?
Anybody can live at the Heritage. We have no discrimination of any kind in the building.
She denied ever talking about race with potential buyers, even after I told her about our investigation.
We've had several people come to us and say that
that you say that this is not a mixed community, that it's only white people are allowed to live here?
No, I've never made that statement to anyone. I would certainly lose my license if I did a thing like that. We do not have a mixed neighborhood here, but I've never made a statement like that.
So here's what's happened as a result of our investigation. Today, Ann Bryant submitted this letter to her employer. She's retiring from real estate effective immediately. To remind her agents, their agents, of the importance of this issue, her former employer is requiring each agent to sign a second ethics policy. Also, I've spoken with the president of the Heritage Homeowners Association. His comments: we don't discriminate in any way at all on the issue of why Bryant has been on hand almost every time a prospective buyer looks at a condo for sale in the building. The president said, quote, she is not authorized by the board to show property. After viewing our tape, HUD opened its own investigation. HUD officials have told us their attorneys will be able to make a decision based on the possible violation of federal law very soon. And of course, J.R. and Darcy will keep you posted.
Well, Johnny, has this realtor had any past incidents?
We found out today, yes, she has. In 1997, a couple filed a claim against Bryant's former employer, naming her and her realtor as accusing her of steering. That's a practice referred to right here in the Fair Housing Act. Protected class, what type of housing or location would or would not be appropriate for them, steering them in that direction. Her employer settled that claim, and Bryant had to pay a fine for that offense. So certainly a lot coming out of this story still to come, and we're going to continue to follow it in the next couple of days.
All right, Johnny, thank you.
Sure.
Well, we also contacted the State Realtors Association after our investigation of the Heritage, and this is how they responded to what we uncovered. Realtors adhere to a high standard of integrity and a code of ethics that requires equal access to fair and affordable housing for all, regardless of race, color, religion, sex, handicap, or national origin. They go on to say, as realtors, we deplore...
He skipped familial status. Maybe he didn't, he wasn't able to pronounce it. I don't know, but he skipped that one.
And will actively pursue action against any member whose actions run contrary to the federal or state fair housing laws or the Realtor Code of Ethics.
Well, we would like to get your feedback on our investigation of the Heritage. There are two ways you can voice your...
Okay, so let me try to fast forward a little bit past this. Okay. So here was the outcome. In 2005, HUD launched an investigation and reached a settlement with her broker, Century 21 Bob Capes Realtors. Bryant had to give up her real estate license, and then she died that year. But that's not the end of it. Jared Glover, a Black public relations specialist for the city of Columbia, South Carolina, who is also that news guy, that Chapel news guy, it was his roommate in college. He sent him in there, as doing one of the undercover things, and he's a Black guy. That was his roommate. When she made those comments, so he sued and filed a complaint in federal court last year that ended it with a settlement against her broker, awarding him $90,000. Keep in mind, she's dead now. But because of her actions, he still was able to sue. He sued the broker because the broker can be held liable for the actions of their agents as well. Let's see, is there anything else to this? All right, so as part of the settlement, Century 21 agreed to provide, that Bob Capes Realtor agreed to provide fair housing training for its employees and outreach in minority communities. Okay, I think that was it now. But
when I was saying her in the beginning, I thought, yes, she's on her she's on her age now.
Yeah, I mean that was something though, right?
She was thinking in last time what maximum she can earn.
I like this example because it was a good case because it showed you from the beginning of it, and someone actually involved in discrimination, and then to it getting reported, then you could see the HUD investigator. that HUD investigator, that black dude that was at the desk, and he was like, this would give me pause into wanting to look further into it. I was like, damn, if that was me, I'd be jumping out of my chair. I'd be like, yeah, we're definitely looking into this lady. You know, I mean, with that evidence that you got right there. But anyway, I like this example because it showed you the cases. It showed you what the Realtors Association's response. You've seen another real estate agent that says, hey, we get regular training on this stuff. You can't even answer questions when somebody asks you what the makeup is. And yet this lady's volunteering the information saying, yeah, we got it all white here. Oh, we got one Asian couple upstairs. They're nice as can be, you know, but we don't, you know.
And she was saying, I'm not listing this because it's going like that.
And just, you know, like she's admitting to everything too. It's, but anyway, hopefully you guys are not going to be doing stupid things like this. You know, hopefully you're going to be treating everybody fairly and equally and selling house. I do see color when I sell houses. The color is green. I don't care about your religion. I don't care about your background. I don't care about your color. I don't care about any of that stuff. I care about finding you a good house and showing myself as a good agent that was working in your best interest so that you could refer me more business. I don't give a crap about anybody's ethnicity or any of that, you know, and neither should you. That's the moral of the story. And we're going to take our lunch break now because we're going to end on that. So I'm going. So enforcement of the anti-discriminatory laws. For the federal laws, the Civil Rights Act of 1866 and the Fair Housing Act of 1968, HUD enforces these federal laws. You have 1 year to file a complaint and have charges heard before an administrative judge within HUD itself, or 2 years if you want to make a federal case out of it and have it heard in federal court. The term injunction is when a judge orders someone to do something, to take action, or to refrain from taking action. For some reason, you need to know that that's usually asked on state exam. You need to know what an injunction is. It's when a judge orders someone to do something, like to rent to someone that they previously denied rental because of discriminatory reasons, perhaps, or something else. So it's when a judge orders someone to do something or not to do something, to take action or not take action. Now, the LAD, we're breaking into the New Jersey law against discrimination now, the LAD. All real estate is covered by the LAD, residential and commercial. So let's back up for a second. What kind of property is covered under the Civil Rights Act of 1866?
Residential.
What happened in 1866?
Civil rights were created.
Well, and who was president back then? Think about that old law.
Abraham Lincoln.
And what did he do?
He ended slavery.
Right? He freed the slaves and said that everybody has equal rights to have to own property, including the clothes on your back.
Mm-hmm.
Right? So it covers all property, real estate and personal property, like the clothes on your back. So the Civil Rights Act of 1860, I'm trying to come up with ways that you guys can remember this. Civil Rights Act of 1866 covers all kinds of property, real property and personal, covers everything. The Fair Housing Act of 1968 has a little clue in the name. What kind of does that cover?
Residential.
Only residential real estate. Does not cover commercial real estate or personal property. Now, the LAD, the New Jersey law against discrimination, covers all kinds of real estate, but not personal property, just real estate, both residential and commercial. So complaints are made and enforced by the New Jersey Attorney General's office. in which time you have 180 days, 6 months to file a complaint. Those who interfere with an investigation are subject to a $500 fine and up to a year in prison. The Attorney General's memorandum, the Attorney General, that position is the highest law enforcement officer in the state or in the land. Every state has a state's Attorney General's office, and then the country has an Attorney General. It's the highest law enforcement officer in the land. So New Jersey's Attorney General put out a memorandum, that's a fancy word for a notice, about the New Jersey laws against discrimination, which needs to be given to the property owners at the time we get a listing that tells them whether they use us as real estate agents or not. They need to follow these laws. So they cannot discriminate. So we have to give, what's the document we need to give to property owners at the time we get a listing?
A CIS form.
We give that to everybody the first when we first meet them, right? Anyone we intend to do business with.
Yeah.
But we need to give them the Attorney General's memorandum.
The 26 notice?
No, the Attorney General's memorandum. The Opinion 26 notice is the cover page of contracts once we're under contract, right? When we're writing a contract to make sure that they have a right to hire an attorney. The document that we give to property owners at the time that we get a listing is this Attorney General's memorandum. It tells them that they cannot discriminate whether they use us or not. That's all it does. We only have to give it to the property owners. We don't need to give it to buyers or renters. Why? Because they're free to discriminate all they want. They could choose where and who they want to live near, right? But if they're searching for a home based on discriminatory criteria, we cannot assist them in those discriminatory searches. So we got to give the Attorney General's memorandum, which talks about the New Jersey law against discrimination, the LAD, to property owners at the time we get a listing. And then we must refuse listings. Licensees must refuse listings when a property owner indicates they may have an intent to discriminate. We have to turn down that listing. Okay. So how do we inform people? What is the attorney? We give them that Attorney General's memorandum. That's how we inform them about the LAD. And the LAD was the Attorney General's memorandum was updated in 2021 to include the FCHA, the Fair Chance in Housing Act, which went into effect in 2022. Right there? No, 2021. Yeah. All right. So the so we have to give to the owners of property when we get a listing, the Attorney General's memorandum with the Fair Chance in Housing Act. The penalties for violating the New Jersey laws against discrimination, it's up to $10,000 for a first offense, up to $25,000 for a second, and up to $50,000 for further violations.
Could that also include license revocation or suspension?
If you're involved in discrimination activities?
Yeah. Would that also be included on the test as well, or just the fines?
No, just the fines. Just the fines. So if you violate the New Jersey laws against discrimination, the fines are up to $10,000 for a first offense. Now, this is most likely not going to be us. When I say you, this is going to be the property owners, right, who are discriminating. Hopefully, you're not going to be discriminating either, but up to $10,000 for a first offense, up to $25,000 for a second. So 10, 25, 50. 10, 25, 50. That's a way to remember what the penalties are for the violating the LAD. as far as the federal laws, we don't need to remember their fines because they're weird numbers, and I'm going to show them to you in a moment. But you see, this is everything you need to know about the LAD. Now, what document do you give people at the time of listing about discrimination laws?
The Attorney General memorandum.
The Attorney General's memorandum. You do not give them the LAD. The LAD is the law. You give them the memorandum from the Attorney General, which talks about the LAD, right? Just want to make sure that you understand that, because I know when I was taking this class, the way I wrote my notes, I got kind of confused because I was like, I wrote the definition of the LAD and I wrote the definition of Attorney General's memorandum, and I'm like, what the hell's the difference? They look like they do the same thing. Well, the LAD is the law. You don't give people the law. You give them the Attorney General's memorandum that talks about the law. Okay, I just want to clarify that because I was in your place before, and I know this confused the hell out of me when I was in your place. So we give the Attorney General's memorandum about the New Jersey law against discrimination. So you get questions on exam on that. Do you give people the LAD or the AG memorandum?
The memorandum.
The memorandum, correct. Correct. And how long do you have to file a complaint under the New Jersey law against discrimination?
6 months.
6 months, 180 days. They may put it either way. That's why I wrote 180 days, 6 months. On exam, they may write 180 days, or they could write 6 months. Okay. And what do we do if an owner tells us they have an intent to discriminate? They don't want you to show the property to these people or those people?
Refuse listing.
You turn down the listing because they give you multiple choice answer options. Turn down the listing or refuse the listing, or explain to them that discrimination is wrong, and then if they agree with you, then take the listing, and they give like a bunch of other options, so. All right, everybody snap a picture of this slide because this ain't a bad slide. Okay.
Got it.
All right, so let's do the highlights now, page 73. This is about violating the federal laws. Who enforces them? HUD. Here we're going to highlight injunction. That's when a judge orders someone to take action or refrain from taking action. And as you can see, the crazy penalties here, you do not need to know these for exams because, look, for violating the federal laws, penalties range from $21,663 for the first violation to $54,157 for a second violation to $108,315. How are you going to remember those numbers? You're not. Don't worry about memorizing them. There's no way that they would expect you to memorize an obscure number like that. Okay, everybody got those highlights?
Yeah, got it.
Okie dokie. So threats or acts of violence. Hold on one second. Before we get into this, I just want to make sure that I have a slide replaced here. I have a note in my book to update and replace a slide. I don't know if I did. Let's see. Okay, I already updated that. Yeah, okay. Oh, no. Okay, so now I do have to update this. Okay, so, what do I got to update? So this screenshot here, I got to just get a new screenshot in there and update it. I think I have one already taken. I just need to get it from my computer to update it. But either way, let me get that piece of paper I threw in the garbage. So this slide right here for these federal amounts, they were updated in 2023. This is now 24,793, 61,982, and $123,315 for further violations. So as far as those fines go, I need to update that screenshot. It's different in the book from the screenshot I have right here. So I'll update that later. I'm not going to do it now, wasting your time. So I just wanted to make the note of that I had that here. All right. So threats are acts of violence. The Federal Fair Housing Act of 1968. Here, let me just explain this. You can't threaten somebody or use violence to get them to move or to buy somewhere. Okay. If you come across somebody using threats or acts of violence, you report it to your local police and maybe the local FBI office, Federal Bureau of Investigation. Okay. New Jersey law against discrimination, the LAD. These are has a lot more protected classes than even the federal laws. You know, New Jersey doesn't want to be outdone by any other agency. So this is on page 74. The protected classes are race, color, national origin, ancestry, nationality, creed. Creed is your doctrine of religious beliefs. Sex, gender identity or expression, affectional or sexual orientation, marital status, civil union status, domestic partner status, familial status, which includes pregnancy or breastfeeding, actual or perceived mental or physical disabilities. That includes AIDS, HIV, COVID-19, and other illnesses. Source of lawful income used for mortgage or rental payments. That includes Section 8 housing choice vouchers, state SRAP, state rental assistance programs, or TRA, the temporary rental assistance programs you get from Catholic charities in the state. Liability for services in the armed forces of the United States. What kind of sick world are we living in now that we have to make people who are serving our country and our military a protected class because people are discriminating against them? What did we revert back to the ages of Vietnam where our soldiers come back and people are spitting on soldiers? You know, this is ridiculous that we have to make them a protected class here. But anyway, they are a protected class, so that's good that they're there. It's also illegal to place any advertisement or make any statements or utterances that express directly or indirectly any limitation to offer housing or real estate based on any of those characteristics. Technically, under the FCHA, ex-convicts, who are now referred to as system-involved people, New Jersey tried softening the language on that, are considered to be a protected class in New Jersey, even though they say specifically, we're not making criminals, people who have committed crimes, a protected class. Yeah, technically they are, because they changed even what you call them. When they're convicts, they've been convicted of a crime. They're called convicts. And then after they serve their time, they're released. They're now ex-convicts, right? So New Jersey's trying to soften that the views on that, and they call them system-involved people. Okay, sure, you went. What the hell does that even mean? System-involved people. That's ridiculous. That's like when they changed what you call garbage men to sanitation engineers. Remember they did that years ago? They do all kinds of weird things like that, but system-involved people. All right, so here's a little guide to remember. This guide is kind of difficult to track. Your eyes are all bugged out on it, but it shows you the different protected classes covered by the different laws. The Civil Rights Act of 1866, the Fair Housing Act of 1968. What is this? The Housing and Community Development Act of 1974. Fair Housing Amendments Act of 1988. Those are amendments that were made to the Fair Housing Act. And the Equal Credit Opportunity Act of 1974. And the New Jersey Law Against Discrimination. Yeah, this bugs your eyes out and trying to figure it out. Okay, so New Jersey LAD prohibited activities are refusing to sell, rent, lease, assign, or sublet as a means of discrimination. For licensees, refusing to offer property or negotiate transactions as a means of discrimination, or lying about the availability of property. Changing the terms of real estate transactions or offering special offerings of special facilities or services to any person as a or group as a means of discrimination. Being involved with any expression directly or indirectly of any limitation based on discrimination. That includes statements, advertisements, publications, signs, rent applications, purchase offers, and records of inquiries. So the only exception to New Jersey law applies to rentals. It allows rooms, apartments, or flats in certain types of housing to be restricted to members of one sex. Religious-based organizations to discriminate on the basis of religion, and an owner-occupant to discriminate except for race in the rental of a two-family house, a duplex or over-under two-family dwelling. Note that these exemptions are similar to those available under the federal fair housing law. New Jersey law, however, does not contain the federal exception for homeowners selling their own homes when a broker is involved. There's never an exception for race, whether a broker is involved or not. That dates back to what law? What law says that there's never an exception when it comes to race or color?
Is it the HUD?
Well, HUD is the Department of Housing and Urban Development.
Civil rights?
There's a couple Civil Rights Act. Which one are you talking about? 1866 or 1968?
1866?
There you go. That's correct. So here's a breakdown of what type of property is covered by each law that I made this chart for you. It's easy to tell at a glance. Personal property is covered by the Civil Rights Act of 1866 and no other law. Residential property is covered under the Civil Rights Act of 1866, the Fair Housing Act of 1968, and the LAD. Commercial property is covered by the Civil Rights Act of 1866 and the New Jersey LAD, but not the Federal Fair Housing Act of 1968. So you can view that at a glance there. I gotta get caught up on my highlights there. Hold on a second. I'll put this on screen for you, and I will continue to go back to where we were. And okay. Convert good. Okay. Need to get my screen snippet app. Hold on. Listen. So adding to those notes. And I think I'm caught up with you here.
I have a question.
Yeah, shoot.
Where could I find those notes again? I forgot that you're writing.
The ones that I'm writing, it's in the new ClassLinks Word document, which I haven't uploaded yet that I've been making the changes to. Hold on, let me see. I could save those changes right now, the updates as of right now, and I could upload them for you right now.
All right, thank you.
Although keep in mind they're in the works, the changes keep on happening. So let me rename this current one that's there. I'll call it new ClassLinks file. And then I'll just load the latest one that I have here. These got a lot of windows open. You could hear me moving through all these screens that I got and trying to find a. Where the heck is it? Good chapters. Oh, here we go. All right, I just added there the new ClassLinks file. You'll see two of them, one that says older and one that says just new ClassLinks file. That's the one that I just added in there. Okay, so New Jersey requirements, the law against discrimination also applies to loans for real estate transactions, whether it's by private individuals or financial, let's see, institutions. Block busting and record keeping. If you get 3 or more listings on one block in a single month, one block or one road, I'm not sure exactly. I'm not sure if this is exactly correct. It says in a block. I'm not sure if the law is actually in a block or a single road in a single month. You need to keep copies of records of your advertisements or your script if you went door knocking that you use to get those listings. and keep them on file for at least a year. So, in case any complaints are made that you were involved in blockbusting, so that we could see what kind of advertisement or script that you used for your getting those listings. And then the poster, New Jersey has its own poster, like the equal housing opportunity poster. Well, New Jersey has its own poster that you need to display in your offices as well if you're offering housing or housing services. However, unlike the federal equal housing opportunity poster, you're not automatically considered guilty of discrimination. It doesn't prove it's not evidence of discrimination if you don't have the poster up on the wall. However, you can get a fine of $100 or more if it's not displayed in your offices. And this is what that equal housing opportunity poster looks like. And enforcement, complaints brought under the New Jersey. Okay, so here, this is the stuff that we already saw on a previous slide. We're just doing the highlights now in the book on page 78. So get these highlights down about the New Jersey law against discrimination, the fines, who you reported to. But it also brings up now one other point here. Anyone found guilty of violating the Fair Chance in Housing Act can be subject to penalties up to $1,000 for a first violation within 5 years of a complaint. For a first violation within 5 years of a complaint, up to $5,000 for a second violation within 5 years, and up to $10,000 for 2 or more violations within 7 years. And that's if you deny renting to somebody who is an ex-convict or, excuse me, a system-involved person. Those are the possible penalties. Let me write that in here. What does it say? Who found guilty? Type that in now. I'll just take a screenshot. So the notice at listing, we're also going to highlight this. This was also on the previous on a previous slide where I had all that information about the LAD on one slide. Well, now we're going to highlight this in the book on page 78, that we need to give a copy of the Attorney General's memorandum to owners at the time the property is listed. And salespeople must refuse listings from an owner who indicates they intend to violate the LAD. Now, I have a copy of this latest Attorney General's memorandum with the Fair Chance in Housing Act in the shared drive in the supplemental materials folder, but I included it in this slideshow, so we'll look at it piece by piece in this slideshow as well. So just let me know when you guys get these highlights down.
I'm done.
Not yet. Hold on.
No, sure.
And I'm finished.
Okie doke. Here, I went and I grabbed it, and I'm going to share this with you. This is the directly from our shared Google Drive, the Attorney General's memorandum with the Fair Chance in Housing Act, the latest one. But the book should be updated with the latest one as well. Yes, they have the latest one in this version book as well. And here we go. So this is the Attorney General's memorandum. Let me update this slide to have a link of that on there too. Yikes. Right, there we go. So you can see the Great Seal of New Jersey there at the top. It looks like an email, right, to property owners from the Attorney General. Date December 2021. Subject: housing discrimination laws. So this is the memorandum that's coming from the Office of the Attorney General, Department of Law and Public Safety, Division of Civil Rights. Now, this is the document that you actually give to property owners at the time you get a listing. This is the Attorney General's memorandum. So New Jersey Real Estate Commission, the REC, requires every licensed broker or salesperson with whom you list your property, they're talking to the property owner here, to give you a copy of this notice. The purpose is to help you comply with the New Jersey Law Against Discrimination, the LAD, and the Fair Chance in Housing Act, the FCHA, which went into effect January 1st, 2022. So the law against discrimination, under the LAD, it's illegal to discriminate against a prospective or current buyer or tenant because of their actual or perceived race, religion, national origin, nationality, ancestry, pregnancy or breastfeeding, sex, gender identity or expression, sexual orientation, familial status, defined as having care or custody of a child under the age of 18 or being pregnant, disability, liability for services in the armed forces of the United States, marital status, civil union status, or domestic partnership status. It's also illegal to discriminate against a prospective or current buyer or tenant because of any source of lawful income used for residential or mortgage payments. And it's illegal to make, print, or publish any statement, including print ads and online postings expressing any preference, limitation, or discrimination based on any of those protected characteristics. So the LAD applies to a wide range of activities, such as advertising, selling, renting, leasing, subletting, assigning, and showing property, including open land. And here's some issues that come up frequently with the LAD. See, older versions of this Attorney General's memorandum never had examples in them. So it was a simple one-page document. And I like that they add examples now, because in the past, we would have to interpret the law for the homeowners to explain to them what they can and can't do. Sometimes that ended up us clashing with them, trying to explain the law. So here they give actual examples of some of the more common issues that we may come across. So let's look through them. The prohibition on discrimination based on source of lawful income means that, for example, a landlord cannot reject a tenant or prospective tenant because they intend to pay with rental subsidies or vouchers provided by federal, state, or local rental assistance programs, including Section 8 housing choice vouchers, COVID-19 emergency rental assistance program, the state rental assistance programs, or TRA, temporary rental assistance programs. The eviction prevention program, which was there during COVID, unemployment benefits, child support, alimony, or supplemental security income. A housing provider cannot advertise a property in any way that discriminates based on their source of lawful income, including by posting advertisements that state directly or indirectly a refusal to accept or express any limitation on vouchers or subsidies. And they give an example here. You can't have advertisements that say things like, no Section 8 or TRA is not accepted, or this property is not approved for Section 8. Those types of statements would violate the LAD. And don't worry about it not being approved by Section 8. Section 8 standards are not that high. It'll get approved by Section 8. In addition, housing providers must calculate any minimum income requirement, financial standard, or income standards based only on the portion of the rent that's to be paid by the tenant, rather than the full rental amount, which may be getting subsidized by the rental assistance programs. The LAD prohibits bias-based harassment in housing, including sexual harassment. If a tenant's being subjected to bias-based harassment that creates a hostile environment, and if the housing provider knew or should have known about it, the housing provider must take reasonable steps to stop it. This includes harassment by other tenants and by a housing provider's agents or employees, which is interesting because it's maybe a little bit difficult to control what other tenants are doing. You know, in the past, if you were a landlord or if you were a superintendent, you would tell people, if you're getting harassed by another tenant, call the police and file a complaint. Now they're leaving it up to, they're making the landlord responsible to take action against the other tenant. But yet, there's laws in place that make it difficult to do that for the landlord. So this includes harassment by other tenants and housing providers, agents, or employees. So a quid pro quo. This is a quid pro quo sexual harassment, for example, is where a building superintendent demands sex or sexual favors as a condition of making necessary repairs. That's obviously prohibited as well. Could you imagine? Well, imagine no more. Here's a case. I found this on the New Jersey 101.5 radio station's website, where this was in 2001, I think, or something like that. Let me see, where does it say? 2020, sorry. On August 8th, 2020. This was in Elizabeth. These are some of the buildings that this landlord owns. And here's a list of a bunch more that he owns. So, federal authorities filed a lawsuit accusing a city landlord who rented to low-income residents of demanding sex from residents on multiple occasions in exchange for assistance. The sexual harassment complaint filed by the Department of Justice in the U.S. District Court in Newark named Joseph Centani, who authorities said owns numerous properties in and around the city of Elizabeth, ranging in size from 4 to 100 units. Centani receives about $102,000 every single month from the Federal Housing Choice Voucher Program, or Section 8. That does not include the additional payments from the tenants or those that are not collecting those benefits. Could you imagine a landlord demanding sex from tenants? He's making all this money. Come on. This guy must have no game whatsoever. He's not able to get himself a woman. The guy obviously is rich, makes a lot of money, and he's got to harass these women. So the lawsuit alleges that since at least 2005 until last year, Centeni engaged in severe or pervasive sexual harassment that included demanding oral sex in exchange for helping residents stay in their housing or to receive rental assistance. Authorities also allege that he threatened to evict tenants who rejected his advances and also demanded sexual favors from prospective tenants. Could you imagine you're checking out a place that you may possibly rent, and the landlord's already harassing you, demanding sex? That's crazy. That is just insane to me. But
it's insane. It's insane.
There you go. It happened though. You know, his name seems so familiar to me. I think I gotta look through my records. I may have had this guy as an appointment trying to sell one of his houses he had in Elizabeth. He had, I think it was a 7 or 8 family house or apartment building. I could even picture where it was. I gotta look at my records, see if I got them still from that far back. I should. And see if that's the same guy. All right, anyway. Here, legal principles of a lease. While it is disgusting and understandable to be uncomfortable living there knowing things like this are happening, if a landlord's employee enters your apartment and then masturbates in your fiance's panties, does that constitute a crime or sexual harassment? What do you think? Nobody was home.
Yes.
The guy just used his pass key to enter the apartment, go into her underwear drawer, and then masturbate in her underwear in your apartment. Is that sexual harassment?
More than that.
If a tree falls in the woods, yeah, that type of situation. Nobody was really there, so who did he sexually harass? I mean, it's disgusting. But is it sexual harassment? I'm sure this guy was planning on getting away with it without anybody noticing. So, has the landlord's employee sexually harassed anyone? Did he have a legal right to enter the apartment to begin with? Can a landlord just enter an apartment without the permission of a tenant?
No.
No. They can only enter without prior permission in cases of emergencies like gas leaks or flooding. Otherwise, they could be charged with breaking and entering. Even though they own the building, they can't just use the pass key to get into people's apartments. Whether it's an apartment building or a multi-family house that you're renting or a single-family house you're renting, the landlord can't just come into it. That's why you sign a lease. What is a lease? Anybody know what a lease does? What's the purpose of this written document called a lease?
The period of lead, you are the owner of that property.
Yeah, but what is the whole purpose of having a lease?
A binding contract.
That does what?
That protects the owner of the house and the resident. It's an agreement between both of them.
Okay, well, it doesn't protect, per se, anybody. What it does is a lease is a legal document where an owner intentionally conveys the property itself to a tenant who's going to rent from them, and it it conveys all the rights that the owner has to the tenant for a limited period of time as defined in the lease document.
Yeah, that's it.
The only rights that it does not transfer is the right to sell the property or to sublease it, if it's written in the lease anyway, or to mortgage it. Otherwise, the owner is even conveying their rights to access that property, to what we call quiet enjoyment, the right of quiet enjoyment, to prevent others from entering the property or disturbing you, right? So a trespass complaint may be filed by a tenant with the local police department under the New Jersey Criminal Code for defiant trespass under New Jersey statutes 2A:39-6. Now, you can find this information in the Truth in Renting booklet. That's where I got it from. I could share that link with you in just a moment. I could share that link with you in just a moment, but let's first watch this video and see what happened here. Yep, what's going on?
Top story tonight, a Hoboken couple says their privacy was violated. Their bedroom security camera caught a maintenance worker going through their things.
But it's what they touched that has them still uneasy. News 12 New Jersey's Erica Such joining us in the newsroom with more on this story. Erica.
The couple tells us they purchased this security camera to just watch out when anyone was in their apartment, but never expected to capture an employee of their building going through their underwear. Take a look.
It said there was a notification for motion, so I checked it.
The Rivington resident Alex Sacchetti says he was at work just a few weeks ago when his security camera in his bedroom captured moments a maintenance worker did something out of the ordinary.
I started watching, and the man was, going towards the dresser. I was like, wow, that's strange. And then he opened it. He was going through my fiance's underwear. And, after I watched the entire event, there was potentially other lewd acts that took place, but mainly just going through my entire apartment.
The worker is seen checking the bedroom door, closing it, and turning off the lights before going into the corner of the room, blocked by pillows on the camera. Sacchetti says he quickly called management and alerted them. That's when this moment shows the man looking at the camera when he answers his radio call to leave the unit.
It was pretty much your whole privacy is violated.
Sacchetti says his fiance has been so upset by the situation, she's staying elsewhere for now. They filed a report with Hoboken police, but were told this.
He had the right to be in here, and apparently anything that took place is not a crime.
The two have been back and forth with Equity Apartments, who owns the complex, but says their responses have been lacking empathy.
There's been some outreach from some sort of manager or something, I'm not exactly sure. But as far as oversight or, hey, so sorry this happened to you, none of that.
And while this situation still leaves him uneasy, Sacchetti says it's a warning for others.
People here or elsewhere that have buildings should just have some sort of surveillance to fall back on.
And the couple tells us they're hoping to switch apartments in the near future. We did reach out to Equity Apartments for comment, but did not hear back. In the newsroom, Erica Such, News 12, New Jersey.
Wow. So basically, the police said that whatever he did in the apartment that was very disgusting was not a crime. But they overlooked something. They overlooked the fact that he was in the apartment. Did he have a right to be in there? Not unless they prearranged with the owner that he could go in there because he was maybe doing pest control or something, or fixing or repairing something, or got their permission. You can't just use the passkey to enter an apartment and start going through people's things. So he could have been charged with defiant trespass. So once again, this can be found in the Truth in Renting booklet. Let me get to a slide where I could copy that for you. 1 second, I get the slide where I can copy that link and share that with you. Where are we at? Slide, down slide. Here we go. This is the Truth in Renting booklet. I'm going to send it to you guys right now. So the Truth in Renting booklet is a document. It's a booklet that's published annually. However, they don't print it anymore. They make it available only by PDF document available for download in both English and Spanish, and from the Department of Community Affairs, the DCA's website. The Truth in Renting booklet explains the rights and obligations of the tenant and the duties and the rights of the landlord. And it goes over a lot of different topics, everything from paying rent to adding satellite dishes or having pets or what have you, to evictions and foreclosures and all kinds of other renter landlord tenant issues. These laws apply to all tenants in the state of New Jersey. However, it's only required to be given, the booklet's only required to be given to tenants that live in buildings with 3 or more rental units available. So not counting the unit that the landlord's living in. So if it's a 3-family house and the landlord lives in one of the units, they're not required to give it to you. If it's a 4-family house and the landlord's living in one of the units, then they're required to give it to you because there's at least 3 rental units available, right? So any building that has at least 3 rental units, the landlord is required to supply this to the tenant and publish it in a public space, like put it in a hallway or something like that. This is the law, and these are all the rules that the landlord and tenants, and there's a lot of resources there for tenants as well to follow or to use. Let me click on one of these, the Truth in Renting booklet. Actually, you know what? Let me open it from my drive, because looking at it from online is a little bit difficult to go through. Let's see, Truth in Renting booklets. If I can locate this. There we go. Well, here's the one I have. I have the one from 2022. Looks like I got to download a latest one, see if there is a latest one or if that is still the latest one. This is the Truth in Renting booklet. Here, let me fit this to the page here. There we go. So this is what the Truth in Renting booklet looks like. It comes from the Department of Community Affairs, Division of Codes and Standards. You could get these updated ones from nj.gov/dca/divisions/codes. And it has a table of contents here, as you could see, covers a lot of issues, from mobile home leases to public housing leases, renewal of lease agreements, cable installation, pets, termination of lease agreements, making modifications to rental premises for people with disabilities, the landlord's right of entry, filing a complaint for unlawful detainer, access to the property, security deposits, discrimination, disposition of personal property, non-payment of rent, consumer fraud protections, credit checks, rent. Yeah, actually, I should get the latest one because I like to see that about doing the credit and background checks anyway. Habitability, we're going to learn about that in another chapter. Reporting house code violations, child protection, window guard screens, carbon monoxide and smoke detectors, the locks, all kinds of issues here. As you could see, there are many, many issues that are covered in this guide, in this booklet. And then there's resources for tenants who may be having trouble making their payments for utilities or the housing itself. They also have access to maybe free legal sources for people who can't afford them. They've got a lot of information here. But the section there where this person went into the apartment, let's look at right of entry. That's on page 11 here. So let me go down to six. There we go. Here's what deals with this. New Jersey law also prohibits a disabled tenant to terminate a lease agreement if they're okay. Right of entry. In general, a landlord does not have the right to enter a residential rental premises without the consent of the tenant or a judgment from the Superior Court of New Jersey. There's no case law in New Jersey that either requires a tenant to give a landlord a key or prohibits a landlord from keeping a key to a rental unit, unless the landlord writes it in the lease. So the landlord does not have the right to come into a dwelling unit whenever he or she wants to enter. However, the courts have generally approved lease provisions that require a tenant to provide the landlord with a key, citing emergency circumstances where a lack of a key could result in loss of life or property in the case of an emergency. Unless otherwise clearly stated in the lease agreement, a tenant disputing a landlord's right to a key can simply refuse to provide the landlord with a key, unless they wrote it in the lease that they needed to. So the landlord can then seek action for eviction based on the tenant's refusal to provide the landlord a key. The court may deny the landlord the right to have a key if the tenant can prove that the landlord has abused the right to enter their premises. Moreover, the landlord may be liable to the tenant for damage or stolen property if the landlord is known to have a key and known to enter a rental unit when the tenant is not at home. In a written lease, the landlord's duty not to enter the premises is called a covenant of quiet enjoyment, which means that the tenant can control who may or may not enter their dwelling unit. Yeah, because the landlord gave you those rights when they signed a lease. So a landlord shall be guilty of unlawful entry and detainer if they enter a rental premises peacefully or forcefully, and then detain or keep possessions of the property, or take property by force or threat of force, or remove a tenant's personal property without their consent. With the exceptions noted above, if a landlord enters a tenant's unit while the tenant is not home, without the tenant's permission, it is forcible entry. If a tenant willfully and without force holds over or remains in the property after they've been basically evicted, that's what all this says, the tenant shall be guilty of unlawful detainer. And if the tenant's found guilty of unlawful detainer, the tenant shall pay the landlord double the rent for the holdover period. Okay. Filing a complaint for unlawful entry and detainer. Let's see. Legal action. Okay, here we go. Any legal action for forcible unlawful entry or detainer, forcible detainer, or unlawful detainer shall be brought before the Superior Court. The court may hear and make a determination in the action. If a landlord enters the rental premises unlawfully, a trespass complaint may be filed by the tenant with the local police department under the New Jersey Criminal Code for defiant trespass, under New Jersey statutes 2A:39-6. There we go. So they could have, that guy, even though he seemed kind of wishy-washy, he could have pressed the issue with the police and said, yeah, okay, so him doing nasty things to my fiance's underwear may not broken a law, but the fact that he was in my apartment does. So I would like to file a complaint for defiant trespass, basically breaking and entering. Right? That would be the case in that position right there. All right, so let me get a screenshot of that, and I'm going to put that in our notes there that I keep making for you guys. Oh, did I close it? I think I did. Okay. Cool. And go back to the slideshow. All right, so housing providers now, let me go back to that slideshow. So housing providers must reasonably accommodate tenants with disabilities, unless doing so would be an undue burden on their operations. For example, if a tenant shows that they have a disability and keeping an emotional support animal is necessary to afford them an equal opportunity to use and enjoy a dwelling, the house provider must permit the emotional support animal even despite a no pets policy, unless they could show that doing so would be an undue burden in some way. You better get an attorney before you start trying to claim an undue burden, because what you're claiming an undue burden may not actually be an undue burden. So it depends. We'll see. A no pets rule cannot be enforced against a person with a disability who has a service or guide animal. And a landlord may not charge a tenant with a disability an extra fee for keeping a service or guide animal. Landlords must permit a tenant with a disability at the tenant's own expense to make reasonable modifications to the premises if such modifications are needed to give the tenant an equal opportunity to use or enjoy the dwelling. You know, just before I closed it, that Truth in Renting booklet, let me open that back up again and go back to what page is that? Something like 11. Yeah, let's go back to that Truth in Renting booklet for a second. I'm going to show you something that I just caught my eye. It says modifications of rental premises for people with disabilities. It's illegal for a landlord to refuse to rent to a tenant because of a tenant's handicap or disability. The landlord is not required to modify the rental premises occupied or to be occupied by a person with a disability. However, the landlord also cannot refuse to make reasonable changes at the expense of the disabled person, as may be necessary to afford the disabled person full enjoyment of the premises. The tenant may be required to restore the premises to the condition that existed before the modification, except for reasonable wear and tear. The landlord may also require a description of the modifications and proof of required permits. See, the landlord may require the tenant to deposit money in escrow account each month to cover the cost of the removal of the modification when the tenant moves out. The landlord can only require the tenant to deposit the money in the escrow account if they could prove the cost of the restoring of the premises to its original condition will be expensive. Payments into an escrow account must be afforded and must cease when the amount needed to restore the unit to its original condition has been reached. Interest on the account goes to the tenant, though, because that is their money that's being held. New Jersey state law also allows disabled tenants to terminate a lease agreement if the unit is not handicap accessible. A lease can be terminated if the landlord refuses to make the unit handicap accessible after the tenant requests that the unit be made handicap accessible and the landlord's unable or unwilling to do so. That's interesting. See, there's a lot of interesting stuff there in that Truth in Renting booklet. So the law prohibits discrimination based on familial status. I actually had an issue with this one time in Roselle Park. It says the law prohibits discrimination based on familial status. For example, discrimination against families with children under the age of 18 and pregnant people. What do you mean pregnant people? You mean pregnant women. Landlords similarly cannot use unreasonable occupancy restrictions to prevent family with children from moving in. So I had an issue in Roselle Park once. It was not my listing. The renters were my clients. And I made an appointment to show the unit, and we had to meet the landlord to give us entry to the apartment. So we met the landlord there, and my client was a husband and wife, and they had 2 small children, and the wife was pregnant. So when we opened up the door, we went in. The landlord, you know, the clients, they went in first, and then the landlord grabbed me by the arm, and he said, "I'm not renting to them." I said, "What do you mean you're not renting to them?" And he said, "Did you see her belly? She's going to pop any day now." I was shocked the way he said that. So I pulled him off to the side. I was like, "What are you talking about?" And he's like, "I'm not going to get in trouble for renting to them." And I said, "Why would you get in trouble for renting to them?" "Well, because Roselle Park has an ordinance, you're not allowed to have more than two occupants per unit, and or more than 2 occupants per bedroom. And there's already 4 of them, and she's going to pop any day now, and I'm not going to get in trouble for renting to too many people." And I was like, "Well, first of all, that baby's not here yet, so you can't count it as an occupant." And he said, "Well, you say anything you want. You just want to earn a commission." And I was like, "Listen, I'm not going to argue with you on this. You need to contact your own real estate agent, or better yet, contact a lawyer." I said, because if you continue down this road saying that you're not going to be renting to them because she's pregnant, you're going to get hit with a lawsuit, a discrimination lawsuit, so fast it's going to make your head spin. I can see that you clearly are not listening to me or my advice. Talk to your own real estate agent, or better yet, your own attorney. And my clients were interested in renting it. And so he went and he contacted his attorney, and his attorney agreed on what I said. And it is true. You cannot, even after the baby is born, an infant cannot be counted as an occupant until they reach 24 months of age. So if he starts renting to them after she has that baby, they could stay there for 2 more years because they do not violate the local municipal ordinance of more than 2 occupants per bedroom. So, which was his whole gripe about this thing. My clients did end up renting from this guy, but this the stuff that comes out of people's mouths sometimes. I mean, I never heard that expression before, she's gonna pop, as a way of saying she's gonna have a baby, she's pregnant. That struck me as odd, and how blatant he was and forceful in saying it. She's gonna pop any day now. That kind of threw me off there for a second, but then they ended up renting. They only wanted to find a place to rent so that they could save up and buy a house eventually. So that's what they ended up doing. And but that's another situation that I came across where most people wouldn't imagine having such conversations with somebody, but yet in the real estate industry, I told you I could write a book about my experiences. Selectively inquiring about or requesting information about and or documentation of a prospective tenant or buyer's immigration or citizenship status because of the person's actual or perceived national origin, race, or ethnicity, or otherwise discriminating on such a basis is a violation of the LAD. Yeah, no duh, we're a melting pot. We have people here from all over the world. So you can't just assume that somebody's an illegal immigrant because because they may not look the same as you or speak the same language as you, or what have you. That is outright discrimination. Okay. Besides the fact of New Jersey waving the magic wand and turning it into a sanctuary city or state. Remember, under federal law, there's no such thing. But, in the past, New Jersey, you may have had to, before you help somebody buy a house, you got to see that they're legally here in the United States. That they're a citizen. And if they're not a citizen, that they're legally here, able to work and such. But no more. That created a can of worms, because then people look at somebody and they look like they're not from here, and then it becomes a discrimination thing because you're judging people based on the way they look, that they may have come from a different country, and they have a different background, and that is discriminatory. So, as explained in the U.S. Department of Housing and Urban Development's April 2016 guidance document, okay, now we're going back to that, the premise of protecting criminals based on those reports from Obama's appointed HUD person, giving guidance that because of widespread racial and ethnic disparities in the criminal justice system, blanket policies that make all individuals with any prior arrests or criminal convictions ineligible to rent violate both the LAD against the Law Against Discrimination, the LAD, and the Federal Fair Housing Act, because they have a disparate impact based on race or national origin. How so? How so? See, nobody's asking these questions. If somebody asked this question, how so, to the politicians who are making these laws, they'd be there fumbling and bumbling and well, the criminal justice system is, we don't have an equal number of white people and black people in prison, so it's disparate impact. So if you go based on their criminal history, then you must be racist. Okay. And are not supported by legitimate business necessity. And housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. For example, applying criminal record-based restrictions against a black housing applicant but not a white one. Yeah, no duh. That is outright discrimination. If you're going to do background checks on everybody, you do them on everybody. But remember the NAR attorney who also said that states like New Jersey passed laws that says doing any criminal background check, absence of any evidence, or having a neutral stance on doing the background checks on everybody equally, and applying who you want to rent to equally based on their criminal history may disproportionately impact people of a certain race, and therefore it's racist, and then it's not allowed. Okay, so not only did New Jersey change its law, but apparently the feds did too in the Federal Fair Housing Act. Okay, they did all this. They did all this stuff in recent years. All this stuff happened under the Obama administration, and then again under the Biden administration. That's when this stuff was passed. That makes the criminals ex-convicts, system-involved people a protected class, even though they say specifically does not make criminals a protected class. The thing is, their whole argument falls flat on its face. Because if you could make an argument that, well, there's more black people in prison than there are white people in prison, so then it's racist against the black people. I could make the same argument that there's more white people in prison than there are Asian people in prison. So does that mean that white people are being discriminated against? You see, if you can't make the same argument apply, and so you're being selective about the argument, it's nonsense. But our politicians do pass this stuff. I guess the people with the biggest mouths that complain can get things changed here. So penalties. If you commit a discriminatory housing practice that violates the LAD, what are the fines? Up to $10,000 for a first violation, $25,000 for a second, $50,000 for a third or more, right? Victims of discrimination may recover economic damages related to discrimination, such as having to pay a higher rent for another unit. So basically, if you were discriminated against and the landlord refused to rent to you, and you had to get another unit elsewhere and pay more for it, you can get that landlord who discriminated against you to pay the difference in the rent, as well as damages for emotional distress, pain, and humiliation. And in more egregious cases, a victim may also recover punitive damages for being put through this. Brokers, now they're talking to us. The broker or salesperson with whom you list your property, or about us, the broker or salesperson with whom you list your property must transmit to you every written offer they receive on your property. How soon? How soon do we need to transmit every written offer that we receive on their property?
Within 24 hours?
Yep, within 24 hours. Brokers and salespeople are licensed with the New Jersey Real Estate Commission, and their activities are subject to the LAD, as well as the general real estate laws of the state. What are the general real estate laws of the state, also known as? Title
11.5.
11.5.
4515.
Sorry,
And
45.15.
the commission's own rules and regulations, called the Administrative Code, or Title
11.5.
11.5.
11 semicolon 5.
Chapter 5. Yep. See, we got to study these things so we can remember those numbers, you know. And that's why I keep asking these questions, to try to keep them, even though we're past them, I want to keep, jarging your memory a little bit. So the broker or salesperson must refuse your listing if you indicate an intent to discriminate on any basis prohibited by the LAD. Now, there are some exceptions. The sale or rental of property, including open land, whether it's for business or residential purposes, because the LAD covers all real property, is covered by the LAD, subject to following exceptions. Note that when the LAD exemptions apply, the other civil rights may nonetheless prohibit discrimination, because remember, when two laws cover the same topic, you follow the more restrictive rule. So the LAD does not apply to rental of one unit in a two-family dwelling if the owner occupies the other unit, or the rental of a room in a one-family owner-occupied dwelling. A religious organization can give preference to persons of the same religion when selling or renting real property. And in certain types of housing designated for older persons, it's not unlawful to discriminate based on familial status. So now we're up to the Fair Chance in Housing Act again. And I'm going to show you how, I think I've already shown you how wacky it is with the explanations, but I told you, don't believe me. Let's see what the law says. Let's see how they wrote it here. So the FCHA prohibits housing providers from asking about rental applicants' criminal records on an initial application or otherwise consider an applicant's criminal record in any way until after they made a conditional housing offer to the applicant, with a limited exception as required under federal law. The goal of the FCHA is to ensure that formerly incarcerated and system-involved people have a fair access to housing around the state. Nothing about the FCHA requires landlords or housing providers to consider a person's criminal record in housing. Yeah, they don't want you to. But what if you do want to? If a housing provider does review an applicant's criminal history after a conditional offer, specific regulations apply. A housing provider must conduct an individualized analysis of the applicant's criminal record and may only deny housing if withdrawing a conditional offer is necessary to fill a substantial, legitimate, and non-discriminatory interest. In whose view? That would be another question, right? Who's making that determination? Okay, I'm going to show you some things. I'm just updating the notes really quick here. All right. So here are some of the specific requirements for housing providers under the FCHA. Housing providers are prohibited from asking about applicants' criminal records until after they made a conditional housing offer, except for convictions of drug-related criminal activity for the manufacture or production of methamphetamine on the premises of a federally assisted housing. What if it was not on a federally assisted housing? Well, then you can't consider it. Or if the applicant is subject to a lifetime registration in the state sex offender registry. There should be a giant asterisk next to that because it depends on some factors too. Even after a conditional offer, a housing provider may not consider arrests or charges that did not result in criminal conviction. They were expunged convictions or convictions erased through executive pardon, vacated or otherwise legally nullified convictions, juvenile, basically something that happened when you were a juvenile, or sealed records. Yeah, duh. That would be common sense right there that tells us that. So, if a housing provider chooses to consider an applicant's criminal history after a conditional offer, they may only consider convictions for murder, aggravated sexual assault, kidnapping, arson, human trafficking, sexual assault, or endangering the welfare of a child in violation of this particular code here, this law, and convictions for any crime that requires lifetime state sex offender registration. However, However, these are the only things you could consider. However, you need to figure out these additional criteria on them. Any first-degree indictable offense or release from prison for that offense within the past 6 years is one that you could consider. Or any second or third degree indictable offense or release from prison for that offense that happened within the last 4 years. Or fourth degree indictable offense or release from prison for that offense within the past 1 year. So even though they tell you you could consider all of these things, you can actually only consider all of these things if they happened to be a certain degree of a crime that happened within a certain time frame, or the person was released from prison within a certain time frame. Can you consider those things? For a conviction that can be considered, a housing provider. Now, do you guys know the difference between first, second, third, or fourth degree crimes? Can you guys be able to judge it and tell me what that is? I couldn't.
I think
Short of having,
not.
yeah, short of having a law degree, I don't know how any real estate agent is supposed to figure this out, let alone a landlord. So for a conviction that can be considered, a housing provider must conduct an individualized analysis that includes the nature and severity of the offenses, the applicant's age at the time of the offense, how recently the offense occurred, any information the applicant provided in their favor since the offense. Yeah, I ain't do it. If the offense happened again or in the future, whether that would impact the safety of the other tenants on the property. Isn't that the whole purpose of doing a background check? And whether the offense happened on or was connected to the very property that the applicant is trying to rent from again. So basically, if they had that, if they had a meth factory in your mom's kitchen in the apartment that they're renting in your mom's house, and they went to prison for that, and they come out and now they want to rent from your mom's house again, that same place, then you could consider it. But if you're someone else, like they used your mom's apartment to run a meth factory, they went to prison for that. Now they get out of prison. Now they're not renting from your mom now, but someone else. You can't consider their meth factory habit that they had there when renting to them somewhere else. Only if it was in a federal housing complex, federally managed housing complex, which I'm just telling you that at this point, but it's going to say that on the coming pages. So just trust me on that for a second until you see it. So if the housing provider intends to consider criminal history as provided under the FCHA after a conditional offer, they cannot accept an application fee before disclosing the fact to the applicant and offering the applicant an opportunity to provide evidence of inaccuracies in their criminal record, other evidence of rehabilitation or mitigating factors. The requirements to be fulfilled using the model disclosure statement on the DCR's website can be found at this link. Now, you know what happens when you go to this link? It actually shows you the stuff that we saw on the previous page. Convictions for murder, all of these things in this list is what that link takes you to. So it's not very helpful. And then down here where it says, if a housing provider withdraws a conditional offer based on a criminal record, they must explain in writing their justifications for doing so using this model notice on the DCR's website. And you know what that takes you to? The same thing you've seen on the previous page down at the bottom. Not very helpful once again. So if the housing provider utilizes any vendor or outside person or entity to conduct a criminal records check on their behalf, they shall take reasonable steps to ensure that the vendor or outside person or entity is conducting the criminal record check consistent with the requirements of the FCHA. The housing provider will be liable under the FCHA for relying on a criminal history inquiry conducted by a vendor or outside person or entity that conducted it in violation of the FCHA if it failed to take reasonable steps to ensure compliance. Oh my gosh. So basically what they're saying here is you can't make heads or tails of this stuff as a landlord. So you're going to hire a professional that knows how to do tenant screening and is compliant with the law and knows the law for these things. So you hire a company to do the tenant screening for you. And if they do something wrong, you're still going to be held liable for it. So housing providers are prohibited from discriminating against those with criminal records. So didn't that just make criminals a protected class? Or ex-criminals, ex-cons, a protected class?
Yeah,
yeah, essentially, right? In any housing notices or publications, they also cannot require applicants to submit a drug or alcohol testing or to provide information from a treatment facility. The reason why they threw that in there is because under federal law, who is considered a protected class? Those in drug treatment programs. However, you can't ask if they're in a drug treatment program. Why make the laws up if you can't even ask the questions? So penalties. If you violate the FCHA, you may be subject to penalties up to $1,000 for a first violation within 5 years of the complaint, up to $5,000 for a second violation within 5 years of the complaint, and up to $10,000 for 2 or more violations within 7 years. I guess you could contact the New Jersey Division of Civil Rights at njcivilrights.gov or call their hotline phone number here for advice. But I don't think they're out to help you. They're out to help the protected class, which is now apparently ex-convicts. So you're probably better off just keeping your mouth shut and rent to anybody and whoever and anybody, as long as they got a job and can pay. And I think that's the whole idea of this law to begin with, because apparently they were having trouble with getting rental units for ex-convicts. But what about those government facilities? How come they don't just rent to them? They don't want to. That's why they carved out some of those laws. They want you to. So that's the Fair Chance in Housing Act. And then you're going to have to now, previously you never had to, but now you have to get the owners to sign and the brokers or salespersons to sign. And that is the Attorney General's, the new Attorney General's memorandum with the Fair Chance in Housing Acts. Okay. I'm just adding these things to our notes here. 1 second. We should take screenshots of this. Probably be a lot easier. Let's do that. Booby dooby doo. Okay, so some other provisions governing New Jersey rentals. A landlord can't refuse to rent one bedroom. Oh, we already went over these things actually, except for one thing here. It's kind of dopey. And this seems like it's more of an agenda for people that were trying to attack those that were questioning where the COVID virus came from. You know, when people were saying it came from Wuhan, China, but then the media and the one other party was saying that you can't say that it came from China. That is being racist, and that is being. They came up with all kinds of other names for it too. I forget what the word is when you despise people or don't like people from other cultures or something. I forget what it's called. Anyway, look at the way that they worded this. A person with AIDS is considered a person with a disability under New Jersey law and is entitled to protections against discrimination in housing. The LAD's protections continue to apply even if the conduct at issue is related to COVID-19. For example, a landlord cannot seek to evict a tenant because the tenant has or the landlord believes the tenant to have COVID-19. Likewise, a landlord cannot refuse to rent to someone who is Asian because they believe Asian people are responsible for spreading COVID-19. Okay, this is just stupid. COVID-19 is a virus. It's spread by everybody. But where did it come from? That's a legitimate question. But trying to now accuse people of saying that they're accusing they don't want to rent to Asian people because only Asian people are spreading COVID-19 is idiotic. Especially when so many people died all over the world and got sick from this all over the world from all different cultures that weren't just Asian. You know, that's ridiculous. So landlords are allowed to enforce health regulations limiting the number of persons allowed for the size of any given apartment. And municipalities do as well, like I said, with that no more than 2 occupants per bedroom. You know, in the past, New Jersey actually had a law that if you had children, that you could not have, if you have 2 children and one is a male and one's a female, that they couldn't share the same bedroom. The reason for that, I guess, people had some perversion thoughts in their heads, thinking that as they're growing up, you know, I guess they had like ancestral thoughts or something about that. That's what it was based on. But you know what? This is that is stupid, and it is also discriminatory. Why is it discriminatory? Because you can't require someone who has 2 children, one being a boy and one being a girl, from sharing a bedroom. Because what if they're poor? Maybe they can't afford a larger rental unit with more bedrooms to have separate bedrooms for everybody. You know, it's a whole ridiculous premise in the first place. You know, when my dad grew up in Pennsylvania, and they had a small house. His mother and father, they had 13 children. I think it was a 2 or 3 bedroom house. How are you going to prevent them from sleeping? You know, the girls or the boys keeping them separate. You know, and you know, just raise your children right, you know, keep an eye on them, you know. But that's a ridiculous and perversion of a thought to have, to create such laws in such a way. So anyway, that law is long gone now, even though New Jersey is still today making crazy laws. Don't believe me? Let me give you a good one. You can do some research on your own on this one too. This was a couple of years back. There was a this is just for your own edification, to break things up a little bit here. Do you know that New Jersey actually repealed a law of what do we call this? I guess incestuous relationships with your parents? There used to be a law against that, but New Jersey now repealed the law. And I found out about this because I saw some sort of one of these 20/20 or 60 Minutes stories online where a woman and her lover wanted to move to New Jersey because their state would not allow them to get married. Oh, that bad state. What did the state do? Why did this state not want to allow them to get married? Well, because she wanted to marry her biological father. So they moved to New Jersey so that they could do it. Oh my God. Welcome to New Jersey, my friends. Talk about twisted state, huh? Anyway, multiple dwelling, I'm full of useless information like that. Apartment buildings with 25 units or more have an obligation to keep a report, to take a survey of the racial composition of the tenants and the methods used to advertise and handle rental inquiries. And the purpose is to monitor possible discrimination if no minorities live there. I wonder how they do this, because they're not asking the tenants. So what, is the superintendent over there trying to figure out what your racial background is? What do they do when you got people who are mixed races? You know, how exactly does that work? All right, let's see these buyers' love letters.
Hi, I'm Charlie Lee, Senior Counsel and Director of Legal Affairs at NAR. As buyers compete in a hot real estate market, they are searching for ways to stand out from the crowd. One method being used is to send a love letter to entice the seller into choosing their offer. While a love letter may seem innocent, they can raise fair housing concerns and risk exposing both the real estate broker and their clients to legal risks. The Fair Housing Act makes discrimination illegal in the sale or rental of housing and prohibits making housing otherwise unavailable because of race, color, national origin, religion, sex, disability, or familial status. Many states and local governments have their own fair housing laws, which can include additional protected categories. The use of a love letter often presents fair housing issues because they often contain personal information about the buyer, such as their race and culture or traditions, as a way of appealing to the seller's emotions. Some buyers even go as far as sending sophisticated packages that include photographs and videos. For example, a buyer might send a letter with a photo of their family around a Christmas tree. As a result, the buyer has revealed their religion, which is a prohibited basis for a seller to base their decision to reject an offer. While it may not be the buyer's intent for the seller to use this information to discriminate, that is essentially the position that a love letter can place the seller. When considering that the information cannot be easily forgotten or unseen, a love letter may ironically cause the seller to be fearful of selecting the buyer's offer because of potential discrimination issues. Therefore, real estate professionals should advise their clients about the risk of love letters and, at a minimum, stress the importance of avoiding including any information in the letter that could be used to legally discriminate. But of course, even a photograph of the buyers could lead a seller to give preference to a buyer or reject them based on race or other background. Fair housing is a high priority throughout the country, and states are closely monitoring the practice of love letters. In fact, just recently, Oregon enacted a law to take effect on January 1, 2022 that bans the use of buyer love letters. Here are some best practices to consider when it comes to love letters. At the outset of the relationship, speak to your client about the risks of buyer love letters and the potential fair housing issues they raise. Remind your seller client that an offer should be assessed based only on objective criteria such as price and timing. If your seller client insists they want to receive buyer love letters, advise them to consult legal counsel and to document their decision-making process in selecting an offer. Avoid helping buyer clients to draft or deliver love letters. Be sure to warn them against revealing any personal information that could raise fair housing issues. Counsel them to focus on the characteristics of the home or other objective information. Lastly, help your buyer clients find other ways to differentiate themselves to win the property. Beyond offering more money, the buyer may consider offering more flexibility with the closing date, additional earnest money, or waiving other contingencies that may appeal to the seller. Thank you for watching this episode of Window to the Law.
Okay, and Mount Laurel, New Jersey. So, anybody ever hear of the town of Mount Laurel? Well, we have some laws that were passed based on some things that happened in Mount Laurel, New Jersey. And for this, we have to understand the history of New Jersey. New Jersey is the third state admitted to the Union in the United States. We have a lot of history here. We're an old state, one of the original 13 colonies. We were the third one added. So we need to learn about zoning discrimination, Mount Laurel 1 and 2. These are lawsuits that were brought about by the NAACP against the town of Mount Laurel, New Jersey. Now, to give you a little background of what happened here, because the book does not say, the town of Mount Laurel, New Jersey in the past, they wanted to improve their infrastructure. You know, better schools, roads, fire department, policing, etc. How do municipalities get the money to do that?
Taxes.
Property taxes, absolutely. They get it from property taxes. And what are property taxes based on, in part?
Your income?
No, size of the lot.
The property taxes. What are property taxes based on?
Lot size, building construction, bedroom.
Municipality?
The area where it is, according to the location.
The value of the property. It's based on the value of the property. In part, a big part. It's based on the value of the property, but it's also based on the tax rate that the state allows a municipality to charge. So the town of Mount Laurel, New Jersey, wanted to improve their infrastructure. So they came up with an idea. They said, listen, the town of Mount Laurel, New Jersey, here's that background part again. They were one of the end routes to something that was known as the Underground Railroad. You guys recall what that was? During the times of slavery, we had something called the Underground Railroad, where people would help slaves escape the South to come up to the North to live free. And the town of Mount Laurel, New Jersey was one of the end routes of that Underground Railroad. So some people, some families, they settled there. Others, they just used that as an end point, as a rest stop before they moved on to other places in the country. Now, so Mount Laurel, New Jersey has a lot of history. And back then, when they had the Underground Railroad there at the end routes, they didn't have zoning laws that dictated minimum and maximum lot sizes to build a house. So people just built houses close to each other, and they built small houses. They chopped down the trees themselves. They built the houses themselves, So you have a lot of houses that were built on small lots. Of course, they were updated over the years since back then in the 1800s, but they built up on the same small lots that they had. You're limited in how big you could build based on that small lot size. So the town of Mount Laurel, New Jersey said, well, we can't exactly raise their taxes that much because it's based on the value of their property. So what we're going to do is anybody who wants to move to Mount Laurel today and build a new house has to have a larger lot size. So we're going to create a mandate that anyone who wants to build a new home here in Mount Laurel is going to have a lot size at least X. Let's come up with a ridiculous number, because the town of Mount Laurel, New Jersey had a good idea, but they poorly executed it. So we'll come up with a ridiculous number, and we'll just say you needed to have at least 1 acre of land in order to build a house. And 1 acre of land is a lot of land to have in New Jersey and could be very expensive. So if you do that, aren't you essentially pricing poor people out of the town from moving in and building a house? So,
Yep.
by the way, the 1 acre is a number I just made up. Okay, I'm not sure what the lot size was, but it was a ridiculous lot size that was discriminatory in nature. And so I just made up the lot size for the purpose of this conversation. So that 1 acre lot size basically requirement basically priced poor people from out of the town from being able to buy a lot and then build a home in that town. So that's where the lawsuit from Mount Laurel 1 came about. The NAACP in 1971 sued the town of Mount Laurel, New Jersey, for illegal discrimination against low-income and moderate-income persons through the use of something that came to be known as exclusionary zoning because of those larger lot sizes requirements. So the court stated that all developing communities had to zone for their fair share of the regional need for low-income and moderate-income families. And in 1975, the court ruled that the poor may not be excluded from residential areas. Well, I guess what that meant is they said that you had to have various types of zoning for larger lots and smaller lots. So in 1975, the court also stated, well, you can't put those really small lots in areas near the commercial zones, so basically you have to have them spread out throughout the town. Okay, so Mount Laurel court decision, good decision. Let's just say Mount Laurel was not being racist in any way, but they just had a good idea, but they poorly implemented it. And as an end result, they were discriminating. So the court corrected that with this lawsuit. So later on in 1983 came a second lawsuit called the Mount Laurel 2 court decision. This second lawsuit filed by the NAACP against the town of Mount Laurel resulted in courts providing specific guidelines for developing communities. No, it did not. The courts required those communities to create their own specific guidelines. On what? It said that all municipalities have an obligation to provide a range of housing. And this was accomplished by allowing for higher density developments, building homes closer together than normally allowed. A 20% set aside. What is that? Well, for every 100 homes built, 20 need to be for low income and affordable housing. And zoning for mobile homes, and a requirement that communities must cooperate with efforts to obtain subsidies. That's money from the state and federal government. And then a panel of 3 judges was appointed by the Chief Justice, was set up to handle hearing cases where people were hardshipped because of these rules or not having them. So as a result of this lawsuit, more than 50% of the towns in New Jersey never created these rules because the courts left it upon the municipalities to create their own rules that they needed to follow. If they didn't follow them, they could be penalized for them. So let me ask you a question. If a court told you that you needed to make up a bunch of laws that you needed to follow, and if you violated those laws, that you would be penalized for them, would you create a bunch of laws? No. So more than half the municipalities in the state of New Jersey didn't. So that's where we stand today. So several years back when Governor Christie was still governor, but just before he was going to expire his tenure, when he started running for president, you guys remember, it was in the news, it was plastered all over the national media as well as New Jersey media for about 2 weeks. Governor Christie proposed to do away with the Mount Laurel decisions because they were full of loopholes. And they were not accomplishing the intended goals of creating the additional affordable housing that the state needs. They don't so these laws never said when these municipalities had to create that 20% of affordable housing. So most municipalities just keep tabs on how many homes have been built in their towns since this law passed, and how many of them were not affordable housing versus affordable housing. And sometime in the future, they need to be built somewhere. Now, they never said where they needed to be built or when they needed to be built, just that the municipalities need to keep tabs on it and then eventually build it. So as a result, a lot of these towns are not getting it. Right now, we're seeing an explosion of these high-rise housing being built everywhere. You guys are seeing this in your towns? I know in my town, I live in London, they're building these housing complexes all over the place. And these other Clark, Roselle Park, they're building them all over the place. So you guys see them? You guys see them around your towns at all?
Yeah. Some have started building.
Do you know that at least in my town, none of these units in those buildings are affordable housing? None of them. How come the mayor of the town, the zoning departments, allowing them to build all of this and not there to be any affordable housing in there? Instead, the mayor just recently made an announcement in my town that they're going to target areas where they're not high rises or multi-family houses. They're basically targeting suburban communities that have 1 and 2 family houses, that they're going to be allowing low-income housing and affordable housing to be built in those areas. You know what? Because single-family housing is racist, apparently. It's the dumbest thing I've ever heard. I think that's a racist comment. You're basically saying that minorities can't afford a single-family house. That's ridiculous. So, I mean, there's tons of minorities that live on both sides of me, across the street from me. So that's a ridiculous argument to make, right? But yet that's the argument he's making. It's a political party argument. Once again, we're going back down to politics. And this is why we've seen a lot of Wall Street investment groups investing in housing, buying up entire communities, which is now artificially inflating the price of homes. You have BlackRock, you had Zillow. They had departments just buying up residential neighborhoods everywhere where there's 1 and 2 family homes, in hopes that the politicians that they were in bed with were going to try to do away with the single family zoning so that they could build high rises and apartment buildings and then make more money. Especially if you have the borders open and the government is paying for housing for these people to live and paying well of what the current market rates are. Ching, 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 ching. You guys see where we're going with this? This is why today, right now, the housing prices are at like all-time highs. But yet the interest rates have not been dropping. You've been seeing President Trump screaming at them to lower the interest rates. How come the interest rates are not dropping while the pricing of homes keeps going up? Usually it's the opposite. Prices of homes go up, interest rates go down. Prices of homes go down, interest rates might go up, to balance the supply and demand there as well. But those are some of the contributors to why real estate's so expensive right now, despite them building like it's going out of style. And there not being enough affordable housing. You could see in New Jersey, we all heard about that farm in Cranberry that they're trying to take to build affordable housing. Well, how come they didn't put affordable housing in these big complexes that they're building? Because once again, politicians are in bed with the developers. They're probably getting kickbacks, and then they're not requiring them to put affordable units in their complexes. So Governor Christie, when he was governor, said, this law is broken. It's not working. We're not reaching our intended goal to build this affordable housing here in New Jersey. So he went to all the politicians in New Jersey, Republicans, Democrats, Independents, and he said, listen, these laws are broken. Let's do away with them, and let's create a new law from scratch that will address this issue without all the loopholes. For the next 2 weeks, all you heard in the national media, as well as New Jersey's media, was Governor Christie proposed doing away with Governor Christie's racist agenda to do away with long-standing protections for minorities and poor people, to do away with the Mount Laurel laws. But that's not what he did. He was saying that these laws are full of loopholes, and we're not getting the affordable housing bill. So after about 2 weeks of being hammered with this, he just gave up. He put his hands up in the air. He said, I give up. I'll drop the issue. And then it slowly faded away. Now, how is this broken? Well, I think a lot of politicians don't want to fix this because they're taking advantage of it. Because this exclusionary zoning thing, do you know that most of these towns that do not have those rules that those self-imposed guidelines that they were supposed to create, if you wanted to build something in town, in one of these towns, and you go down for a building permit and your city says, no, you can't build that, it's not zoned for that in that area, you can sue the city and appear before this 3-panel of judges that they put together to say that you've experienced a hardship because your town won't allow you to build this, but yet they did not put together the specific guidelines that the Mount Laurel 2 court decision required of them to do. The court will review it, and if that is true, they'll say, you know what, you're right. So therefore, we're going to grant you the ability to ignore your municipality's zoning laws and build whatever the hell you want. Now, the purpose of this law is intended to create affordable housing. But what these builders end up being able to do is ignore the zoning laws and build whatever they want. And affordable housing gets built. They build something else. You guys familiar with Cranford at all? Everybody here familiar with Cranford? You know
I've been to Cranford a lot of times.
You know where the Cranford train station is?
Yes, I know where that is.
Across the street from the Cranford train station for blocks and blocks and blocks. That used to all be single-family houses. And some developer started buying up the single-family houses over there. And then he went to the city with a plan to build storefronts with condos above them. And none of that is affordable housing. And the city said, no, that's all zoned for single-family zoning. You can't build that there. So he sued the town of Cranford under a lawsuit that's called Builder's Remedy, which would allow them to ignore the local zoning laws and build whatever the hell they want. And they got granted that, and that's what they did. Now, across the street, all you see are those storefronts with a living space, the condos above it, and those things ain't cheap. There are no affordable housing there. That's how they were able to ignore the zoning laws and build all that.
And it's actually common to be near train stations, those kinds of apartments. Like when I took the train to New York, when I passed by Linden train station, they're building like this massive condo there, like next to them.
They did it a couple of years ago. So you got Raleigh, you got Linden doing it, you got, I mean, it's all the way down the line, you know. But yeah. So anyway, we got a story about the Mount Laurel court decisions and the backstory about what happened in Mount Laurel all those years ago and what happened over the years, these court decisions and how they were implemented, and then the lawsuits where developers are using them as loopholes to build their projects that have nothing to do with low-income housing, but they're using a low-income housing law to ignore the zoning laws so that they could build whatever they want. So that's what Governor Christie was arguing about when he was still governor, and he got attacked for it because those politicians don't want to give that up, because I'm assuming a lot of them are investing in some of this construction that's going on, or there's some of their construction buddies that are investing in their campaigns and whatnot. So either way, what do you need to know for exams? Because you will absolutely positively get questions on this on your school and state exam. This is what you need to know. This definition right here, just this little blurb. Exclusionary zoning is a discriminatory zoning practice outlawed by the Mount Laurel court decisions, which discriminated against low-income persons, the poor. That's what you need to, that's the definition you need to know for your exams. Obviously, the book's definition and explanation doesn't state anything that comes near that. It may in a much later chapter, actually, but it does not here.
I have another question, teacher.
Yeah, sure.
Isn't it what happened with Hoboken? Because I remember taking a separate course that Hoboken years ago was like Camden. It was dangerous area. It was like nobody wanted to go through there. But then Hoboken like started building like these new complexes, condos, and like and so now it became like more expensive Hoboken, and like it's no Camden no more. Is that like a form of
every yuppies moved in from New York, right?
Yeah.
Yeah, so yeah, I guess they did those developments, but the town was on board with that, though. I don't think they were fighting it. In these cases, you got towns that are fighting it. They're saying, "Oh, that this is not zoned for that. You cannot do this." And then they sue the town because with the passage of these laws, the laws basically said that they set up a panel of 3 judges appointed by the Chief Justice to listen to similar cases. These cases where people explain that they're experiencing a hardship, that they're not able to build their housing project that would allow more homes to be built closer together than normally allowed because it's zoned for single-family zoning over here. And then what they end up building is storefronts with a bunch of condos that are expensive upstairs. They kind of game the system there, huh?
Yeah, totally.
So here we go. Here's a slide. I put this one together here for you about Mount Laurel. Exclusionary zoning is a discriminatory zoning practice by the Mount Laurel court decisions, which discriminated against low-income persons, the poor. The lower-income individuals may not be excluded from residential areas, and it also stated that municipalities have an obligation to provide a range of housing. And then I gave you the note here about builder's remedy, like I've explained it. It was a lawsuit against the municipality by someone, a builder, who has been disadvantaged by local zoning laws, where the municipality has not put in place a written plan on how to handle the creation of the housing for those protected under the Mount Laurel decisions. Allowing builders to construct projects do not meet the current zoning regulations of a municipality. Let me see, those protected under the Mount Laurel decisions. Let me reword that a little bit. Let me get to the editing screen here. And let me reword that to say a written plan to handle the creation of low income and affordable housing. As required required by the Mount Laurel court decisions, allowing builders to construct projects. Okay, there we go. That's a better definition. And then I'll put that note in there about builder's remedy in the notes too. Yeah. So, like I said, don't trust me. Go ahead and do a Google search. Try Googling New Jersey builders remedy lawsuits and see all the different lawsuits that come back. Now, New Jersey recently tried to, there's been some legislature that recently tried to redo some things with the Mount Laurel court decisions, but it didn't get rid of the loopholes. Trying to light a fire under some of these municipalities' butts to build that affordable housing. Okay, so we have Code for Equality, standards of conduct for realtors. Realtors have an affirmative pledge to offer equal service to all persons. And HUD and NAR often have these fair housing partnership programs for educating the public, founded on the principle of focusing on achieving fair housing through local community initiatives. So what's the implication for brokers and salespeople? Well, we need to display a poster, the HUD, as well as New Jersey's equal housing opportunity posters in our offices, right? We have to prominently display a sign stating that discrimination is against public policy as well as state and federal laws, and make proper responses when clients express discriminatory desires. We're going to also learn that reverse discrimination is still discrimination. It's got it right in the name. And we're learning about advertising, what you can and cannot say in ads that may or may not be deemed discriminatory. Yeah. Let's see. So I showed you a screenshot of this earlier, but now we could highlight it. We're finally at it on page 86. The complainant does not have to prove guilty knowledge or specific intent, only the fact that discrimination occurred in order to be found guilty of discrimination. So if a prospect expresses a locational preference for housing, they're searching for a house, and they say, I don't want to be by these people or those people because their housing location preference is based on race. The association's guidelines, the Realtors Association's guidelines, suggest the following response. To me, it sounds kind of robotic, though. You guys got to find a better way to talk to people and just let it flow better. They say your response should be, I cannot give you that kind of advice. I will show you homes, several homes that meet your specifications. You will have to decide which ones you want. Okay. That's kind of robotic, isn't it? If somebody tells me they're searching for a home, but they want, they don't want to be by these people or those people, I'm going to say, listen, I can't search for homes based on those criteria. It's discriminatory. If you want to tell me exactly it is that you want to live, I could search for a home in that area for you. But I can't search for homes for you based on who lives in an area. I could search for homes based on their price range, their architectural style, how many bedrooms and baths, and all of those features of the house. But I cannot search for homes based on who lives in an area or who does not live in an area. Okay? And I'll just spit it out like that. I'll say, listen, I'm not going to lose my license or get fined because you want to discriminate. I'm not going to engage in that kind of activity. But if you tell me where it is that you want to look for a home, I'll look for a home there that meet your criteria. I can't search for homes based on who lives in an area. Okay, that's the way I explain it to people, and it's been working pretty good for me. And you get a chance there to embarrass those who talk like that. And when I've done that, I recall on several occasions, I had this one listing in North Brunswick where I had a lot of people calling up and asking the question, who lives there? And I said, well, the owner lives there still, but she's going to deliver it vacant. She'll be out before you close on the property. And they were like, no, who lives in the area? So, ma'am, I cannot divulge that information. It's discriminatory. It's illegal for me to talk about that. That's your response. If you'd like to, I could set up an appointment and show you the property, and then you could walk around the neighborhood, talk to the neighbors, and see if it's a place that you would like to consider.
What about if they ask like a direct question?
I cannot search for homes based on those criterias, and I cannot talk to you about who lives in an area. First of all, I have not done a survey of who lives in an area, but I'm sure they're very nice people.
Wow. There's a lot of safety going on with your talking when you talk to a client.
Well, I mean, you could get people that, could say, I don't want to live by these people or those people, or I want to live by my people. I want to live in a community that either has a high Hispanic or Jewish or Indian population or whatever it is, I can't search for homes based on those criteria. You tell me where that is. New Jersey's a melting pot. We've got people that can live wherever they want, And then what's going to be the argument then? Is there a certain percentage of these people that can live or cannot live in this area that you want me to look for? I mean, how's this exactly going to go down? How's that supposed to work? My job is hard enough to find you this much house in this price range, and now on top of it, you want me to survey the community to see who lives there? Oh my God! I need to be charging you a higher commission. Our job is hard enough without having to look for that. Usually people have an idea of where it is they want to live anyway. So just throw it back on them. Where exactly is it that you're looking? And I could search for a home in that area that you want me to look for you. But don't ask me to look for a property where these people or those people are or are not, because that's a violation. That's discriminatory, and it's illegal for me to do. I could lose my license. And quite frankly, the commission's not worth my license. So I'm not going to risk my license over this. Be direct with people. I'd like to help you find a home, but I can't search for homes based on that criteria. Please don't bring it up. I don't want to get in trouble for this. In all the time up there, I've had people ask the questions, who lives in the area, a couple of times. But I haven't really had that many people ask outright discriminatory questions, But I did have this one guy one time. I'm not going to mention the name of the franchise, but this guy was in charge of establishing a franchise for a food franchise across New Jersey, Pennsylvania, and New York. And so he chose New Jersey to live in to find a home because it's right in the center. And he's telling me, I don't want to live by, like, he was like racist on everything. He's like, I don't want to live by these people. I don't want to live by those people. I don't want to live by those people. And I was like, holy shit, this guy's, pardon my French. I was like, holy moly, this guy's asking me these questions like he's so boldly, I guess he, whatever. So I told him, listen, I can't search for homes like that. I was like, listen, you're moving to the wrong state, buddy. I was like, this is New Jersey. We're a melting pot. We got people from all kinds of backgrounds. I was like, good luck finding a house where you got nobody like this or like that, unless you're going to live in a rural area where there's like nobody living around you. Yeah, you're going to have people from all kinds of diverse backgrounds here, I said, and I can't search for homes for you based on who lives in an area, just based on the criteria of the home, the price range, how many beds, how many baths, architectural styles, those kinds of things in the towns or sections of town that you want me to look. So the next time I seen him, he set up an appointment, came back. Next time I seen him, he brought a laptop with him, and he found some website that shows all kinds of census data and breakdown based on demographic data of people who live in a town. And I was like, I'm not looking at this because I showed him a bunch of listings that I prepared from different areas, and now he's going through them and saying, well, where's the address of that? And then he's putting in the address, and he's like looking at the composition of people that live in the area. He's like, oh, no. And I was just like, oh my God. I was like, here's the whole list. You go through them. I'm just going to let you doing this, But buyers and renters are free to discriminate all they want. We just cannot assist them in that discriminatory search. Okay, moving on.
And you can choose like if you want to continue like helping him or no, just because he's using.
Yeah, but I mean. Yeah, you could just turn away to people too. The guy's gonna find just one way or another. I just didn't want to be involved in his searches the way he was doing them, So as long as he tells me where he wants to find a house, or I could turn over a list of properties, he can look at them on his own time and make up his reasoning why. Listen, most of the time we don't know why people. I know this guy because he was so outright with it, But most of the time we give people homes, we send them homes that meet their criterias in different areas. I don't know how they're comparing it or making their decisions why they want to buy one house over the other. That's their personal decision to make, and they're free to discriminate till their heart's content. I just can't assist them in doing it. I don't know every single person that I ever sold a house to wasn't discriminating. I don't know. As long as they don't have the conversation with me, I don't want to enter in that conversation. I'll show you the houses that meet your criteria and sell you the house, or rent you the house. But I don't, but I'm not going to engage in any discriminatory rhetoric with you, So that's why when this guy came with that laptop, I was like, here, you take all of them, you go through that in your own time and let me know, and then I'll set up the appointments. It's like, I can't be a part of this. So that's just what I told him.
Oh, okay. Thank you.
You're welcome. It's not so common so that you're going to have to come across. You may never come across this, okay? This was one time that I came across somebody like that was so outright like that, But a couple other times I've come across it. It wasn't people that were discriminating, that they didn't want to be by certain people, but they wanted to be by certain people. There's a big Haitian community here, I want to live over here. Or there's a big Indian population, I want to be by my people over here, Or there's a big Hispanic population here, like the guy in Elizabeth that I tried to tell him you could get a house in Westfield for this. And he was like, oh, no, my people over here, Is that discrimination? I was like, enough said, you made the decision. I'm not going to try to redirect you somewhere else, but I'm not also going to engage in the conversation to dig in deeper on it either. All right. Reverse discrimination on page 86 is actually a thing. Yeah. In recent years, brokers sometimes been caught in the middle where local governments enact well-meaning quotas. Oh, when you're talking about races of people and mentioning the word quota in the same sentence, that is not good. So let's highlight reverse discrimination regulations are intended to preserve racial balance in given areas. In other words, you're making up an excuse that your intent is well-meaning, kind of like Obama's intent was well-meaning when he made those race maps. If he wanted to speed up the integration process, but nonetheless, it boiled down to violating every federal law by looking at people based on their color and their background to try to mix them with each other and steer them in one direction, which every premise of that was illegal, you know. Okay, so look at this. Your intention to preserve racial balance in given areas is even worded in this book like it's an excuse. But then at the very top of the page of the book, it says the complainant does not have to prove guilty knowledge or specific intent, only the fact that discrimination occurred. Right? So this is towards the bottom of page 86, above advertising.
Where's that arrow pointing to? Where's that on the page?
Yeah, I'm trying to get something. Give me 1 second here. I'm gonna write it right there on the slide. Okay. So this is actually on the top of the page. So on the top of page 86. First paragraph. All right. And this is last paragraph before the advertising section on page 86. You see it now? Oh, look, I got them backwards. There we go. You able to find them now?
I was able to find it. Yep.
Yes. Yeah.
Okay. So the reverse discrimination thing is in the last paragraph before the advertising title on page 86 at the bottom of the page. Guess I should take a screenshot of that and put it there as well. Did I close that again? Do. So here's some advertising rules. And here's some advertising rules of what you can and cannot say in advertisements that could be deemed discriminatory. We got a little guidance here for you on that. And there's a category, the rule that's permitted is not permitted. Let me just get a screenshot of this really quick, and then we could go through it. Actually, this is going to take a few minutes, so let's take a 2-minute break for the bathroom. I'm doing the pee-pee dance over here, so let's let's just try to take a quick 2-minute. Okay, so advertising rules. This is what we can or cannot place in ads. This is not about what we can say or not say to people that we're talking to. This is about advertisements rules. There's a category. The rule is basically the same up and down the aisle here. No discriminatory preference or limitation can be expressed. What you're allowed to say in ads and what you're not allowed to say. Some examples. When it comes to race, color, or national origin, the rule is no discriminatory preference or limitation can be expressed. You're allowed to say things like master bedroom or good neighborhood. You're just describing things. A good neighborhood is kind of subjective anyway. It's your opinion. That's your puffing, right? Master bedroom is not considered a racist term. How race obsessed do you need to be to consider the term master bedroom a racist term? Does anybody know, by the way, what a master bedroom is?
The biggest room, like elaborate one.
A lot of people think that that's the case, that it's the largest room in the house, and it usually is. But it does not. Not every house has a master bedroom. So even though the master bedroom usually is one of the largest bedrooms in the house, that does not alone make a master bedroom. What makes a master bedroom is that it has a bathroom in it as well. A lot of houses don't have that bathroom attached to or in the bedroom, right? So not every house has a master bedroom. It is a feature. Would you consider it a desirable one?
Yeah.
Yeah, a lot of people do. So not every house has a master bedroom. A master bedroom would be a desirable feature, but not every house has one. What you're not allowed to say are things like white neighborhood or no French. When it comes to religion, no discriminatory preference or limitation can be expressed based on religion. But you are allowed to say in your advertisements, chapel on premises, kosher meals available, or Merry Christmas. And it's not considered that you're targeting Christians or Jews or what have you. You're just describing features here. There's a chapel on the premises of the property where we're selling this unit or renting this unit. There may be. Or if that property has a kitchen that serves meals and they have kosher meals available, you're just describing a feature that's on the property, not what's in the neighborhood, but what's on that property. If you start talking about, kosher meals available in the neighborhood and all kinds of things like that, it could be that you're, targeting Jewish people, or maybe putting out a dog whistle. Hey, Jewish people are here. Merry Christmas. It's a greeting. Merry Christmas. Happy Hanukkah, happy Kwanzaa, happy Festivus for the rest of us. If you're, one of those fans of that show that had that Seinfeld. Or what's not permitted. You're not allowed to say things like no Muslims, nice Christian family, or walking distance to synagogue. Now, I know this is a feature that is definitely desirable to Jewish people who, or devout Jewish people who have to, walk to the house of worship. They do a lot of walking. And I've sold houses before where the owner wanted to insist on me pointing out that this is walking distance to the synagogue. And I said, well, you cannot use that in the ad. And she said, why not? Whoever's going to buy the house is probably going to be a Jew, and they're going to need to be, that's a selling feature. I said, well, yeah, but you're targeting Jewish people, and you can't just offer the house to only Jewish people. That's discriminatory. That's illegal. So what we could do is we could write there walking distance to houses of worship. And if that's someone that's important to, they'll call up and ask what kind of house of worship, and at which point we could tell them. But we can't write that in an advertisement, because walking distance to synagogue is pointing out either targeting Jews or can be construed as a dog whistle. Hey, there's a lot of Jews that live around here, So you're not allowed to do that. You got to be more secular in your language, in your advertisements. When it comes to sex, no discriminatory preference or limitation can be expressed. You are allowed to say things like in-law suites, mother-daughter, or female roommate sought, and they're not considered discriminatory terms. Now, an in-law suite and a mother-daughter are the same thing. They describe the same thing. Does anybody know what an in-law suite or mother-daughter is? Has anybody heard this feature before?
It's like a home inside a home, basically, like a smaller suite within a house.
Yeah, it is a single family house that is set up like a two-family. Has a separate entrance. It has like a separate apartment with its own entrance, has its own kitchen and all that stuff, bathrooms, bedrooms, all that. This is good for people, for example, that often search for this, or maybe you got a couple, they got married and they want to keep their aging parent near them. However, their parent still has the ability to come and go on their own. They got all their faculties. So you want to keep them close, but yet they could be separate, So they've got that separate apartment that's available for them in your house.
It's considered a single family home?
It is considered a single family house. You cannot rent it out. I mean, you could always buy a two-family house, but this is for people who desire a single-family house that have that separate setup where they want the in-law, one of the people's parents to be close by, but not that close and all in your business. You know what I'm saying? So it is a desirable feature. It's a highly desirable feature. So if you do see a house like this, I do suggest that you check off that feature so that agents can search. You could actually search the MLS for that feature. Unfortunately, a lot of real estate agents don't know what the hell a mother-daughter in-law suite is, so they don't do it. Or they may write it in the comments instead of checking that box as a feature, which you're able to do so that people can then search for it. Now, why is a female roommate sought? Isn't that discriminatory that you're looking only for a female? It is not.
Yeah, I was thinking that too.
It is not, because this is somebody who's going to be living with you in the same apartment or house or what have you. You have an extra bedroom in your apartment. You don't want that old guy creeper answering your ad. Oh yeah, I'd like to live with you, honey. You want to have, you feel comfortable having another female there with you. So you're allowed to advertise it that way, and it's not discriminatory. You're not allowed to say things like great house for a man. Why not for a woman? Or the other 50,000 genders that are out there, right? Wife's dream kitchen. Why, you got to be married to have a dream kitchen? Or what about the husband's dream kitchen? Or what about just the man? Or how about just dream kitchen? You know, don't use terms like this because somebody who's hyper offended by everything is going to find a way to get offended by words that you put in your ad. So you're better off just using just straightforward terms like dream kitchen or great house. Doesn't need to be for a man. Don't use terms like man cave or she shed. You could use those when you're showing a house and walking around and say, yeah, this house, wouldn't this be a great place for a man cave for you? You could put your pool table here. You could put a and or put this like a movie theater set up over here where you could hang out with all your buddies and, you know, have a few beers or something and you're shooting some games of pool, you know. If you wanted to insist on putting something in there to the effect of a man cave, you could do something that's more secular and put in there grotto. Ooh, sounds classy. You're classing the place up a bit. A grotto. You know what a grotto means? It's actually Italian. You know what it means? Cave-like environment. So there you go, man cave, a grotto. Yeah. Remember Hugh Hefner in the Playboy Mansion? He had the grotto. Okay, and then she shed. Anybody ever hear of a she shed? Well, on the next slide, I have one. So let's go to the next slide for a second. You guys ever see one of these commercials?
Well, it finally happened, Zachary. Somebody burned down my she shed. Nobody burned down your she shed, Cheryl. Well, my she shed's on fire.
Your she shed was struck by lightning.
Zachary, is my she shed covered by State Farm?
Your she shed's covered, Cheryl.
You hear that, Victor? I'm getting a new she shed.
She shear?
Mm-hmm.
That's wonderful news.
Go with the one that's here.
All right. So, but check out that she shed. Man cave is an escape for the man, and he usually likes to take over the basement, you know, and put a pool table down there or a card table, something he could do with his buddies and get away from the family for a few, but yet still be there in the house. You know, this concept of a she shed. Look at this thing. Got the chandelier there. Look at this get up in this place. They got electrical and a chandelier hanging from the ceiling and stuff. They turned a shed into that. So that's a she shed. Okay. By the way, you cannot rent out those things. If you do finish a shed and you put running water in it and sewer pipes and run electricity out there, maybe have heat or something in there, do not get the idea of renting that out. You cannot rent out your shed or your garage for someone to live in. That is not a legal space to live in. And you may think that you could get and get some extra money, but I know somebody who did that. They finished up the shed with insulation, had running water and sewage and a bathroom, and they even had a little mini kitchen in there, electricity and all that stuff. And they had this construction worker guy living there. He was single now. He was living there. And he didn't show up to work for a couple of days, and people were concerned because he's very timely. And it turns out somebody went to check on him, and he died. Not because of living in a shed, but he died of natural causes. So the owners of the property called the police, you know, the 911, the emergency personnel, to respond to it. And then they were like, why the hell is this guy living in a shed? And then the city looked it up and seen if there was permits for this or anything, and there was not. So they got fined tens of thousands of dollars. This was in Perth Amboy. One of my friends, his father, did something like this. Okay, when it comes to disability, no discriminatory preference or limitation can be expressed. You're allowed to use terms, though, like wheelchair ramp, walk to shops, walk-in closets, jogging path, or walking distance to shops or stores or whatever. And it's not considered discriminatory against people who can't walk. Okay, you're describing features or distance. That's all that's doing. This is only hypersensitive people that are offended by everything that would take offense to this. You are not allowed to say things like no wheelchairs or able-bodied tenants only, and I don't know why you would. I would highly suggest that you keep your ads positive. I keep my ads so positive, I don't even like putting sold sign riders on the real estate signs, because that chases away people that would normally still call. You know, and you could have them call and tell them, well, that property is no longer available, but I could show you something else, you know. Same thing with this. No wheelchairs or able-bodied tenants only. You're chasing away people that may have disabilities but are still going to buy a house or rent, right? So I actually had a situation like this once, and there was a condo, well, not more than once, but there was a condo called the Waterford in Edison. And that is a 3-story condo, but it's the stairway is it's a winding stairway to get up to the 3rd level, the 3rd floor. There's platforms at each level, you know, but you got to go to the stairs to get up there. So I put in there, I described it as a third story walk up. And I had somebody call up, and the guy said, listen, he's like, is there an elevator there in the building, or a way that I could put a ramp in? Because I'm actually bound to a wheelchair. I mean, I could stand up and maybe take a step or two, but that's kind of difficult for me. I'm pretty much wheelchair bound. Is there a way I could put a ramp up there, or is there a elevator? And I said, no, it's actually a winding stairwell to get up to the 3rd floor. But if you want, I could take a look and see if there's any 1st floor units there, or maybe in a local complex, if you're open to considering another complex. And he said, yeah. So I got him as a client looking for 1st floor units for him. Instead of chasing him away by saying, yeah, no wheelchairs or able-bodied tenants only, or 3rd story unit without access to handicap, whatever, you know. When it comes to familial status, no preference or limitation on family size or the type of family or nature of the family. You're allowed to say things like 2 bedrooms, family room, or quiet neighborhood, and they're not considered discriminatory terms. I don't see how they would be. You're not allowed to say things like married couples only, no more than 2 children, retirees' dream home, or no young children. Okay, I've seen this before. People put in there no young children when it was senior housing or 55 plus complex. Keep your ads positive. Don't put stuff like that in there. Just put in there it's a 55 plus community or a senior housing. You know, you could describe, if they call up about it, you could explain this to people. So HUD, the Department of Housing and Urban Development, has what we call testers. It's kind of like an undercover mystery shopper that is not employed by HUD, but is trained by them on how to test people that offer housing or housing services to see if they are engaging in discriminatory activities or rhetoric. So they pose as buyers or renters. They may start trying to hook you in to see if you take the bait and start talking in a discriminatory way. So they may start the conversation trying to engage you in some sort of a discriminatory conversation. They could be the same race as you, or the opposite, the same sexual identity or gender or sexual orientation, or the opposite. The same religion or the opposite. You get the idea. Basically, they're trying to hook you in and test you to see if you're going to take the bait and start engaging in discriminatory rhetoric and conversations. And if you do, they got you. So they're trained by HUD to test you out. They're like undercover mystery shoppers that do that. Now, they're not employed by HUD because that would be entrapment if HUD hired and paid people to go out there and try to get you to do something illegal, right? That's like police. Police can't do that. They can't try. That's entrapment. They can be the same sex, gender, race, orientation, or the opposite. Blah, 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 blah. So what do we call these people? Testers. You're probably going to get this on exam. You need to understand what a tester is. These are undercover volunteers who are on some social justice mission to make sure that no agent out there is engaging in discriminatory banter. To me, that's they're wasting my time. And if I find out they're a tester, I'm going to be mad. I was like, you just wasted my time pretending to be a buyer or a renter. I got to show you properties, and just so you could test me out and see if I'm going to engage in some. You're wasting my time. That's why they pretend to be buyers and renters. You'll never know if they ever were a tester, because if you didn't do anything wrong, then they disappear and their phone number doesn't work and you can't reach them anymore. That's what they do. That's their thing. Okay. You may not like it. You may not appreciate them wasting your time, and I don't blame you. But that's their thing. That's what they do. HUD. These are the HUD testers. All right. So let's highlight that now on page 88. Testers or checkers are undercover volunteers who want to see whether all customers and clients are being treated the same. I remember I had a girl one time. She came looking for a house. I had a listing in Roselle. It was a beautiful house. Huge property. I met her there. She got there a little bit early, so she already walked the yard and looked at the property. I opened the door, I let her in and started showing her around the house. The house is beautiful. This guy meticulously maintained it. He already moved to Florida, so the house is vacant. I showed her the house. She loved it. She loved the price range. She loved the yard. But she said this to me. She said, I came from the Parkway and I had to drive around an area to get to the house here, where I had to drive by some fast food joints. And then I had to go through a neighborhood that had a lot of Black people in it. She said, I don't want to live in a ghetto. I don't want to live in some place where there's all Black people and fried food places and stuff like that. Like, she's throwing out all kinds of racist stereotypes and stuff and rhetoric. And in the meantime, I was about to put the keys back in the lockbox. So I finished doing that. I put the keys in the lockbox, and then I stand up, and then I start leaning against the railing. She's on one rail on the porch, and I'm on the other. We're just, and she keeps talking to me like this about this stuff, and I'm just like, I'm not chiming in. I'm not saying anything. I'm just looking at her, and like my eyes are kind of bugged out. I'm trying not to look bugged out by this, but I'm just looking at her, and I'm like, just taking in, letting her say whatever she's saying. And the thing that was really odd about it is that she was a young Black girl. So she's Black, and she's talking about how she don't want to live by all these Black people, and she's throwing out all these racial stereotypes. And I was just like, okay. You know, I mean, what do you say? What do you say to somebody that's talking like that? So I was just like, okay. I was like, so after I let her finish saying whatever she had to say, and I was just like, I didn't even address any of that. I was like, so do you have an idea where it is that you want to live? And I started getting into that conversation. I could have sworn that this lady was a tester, you know. It turns out she was actually a really sweet girl. She just didn't know how to explain what she was looking for or realize how it was coming out of her mouth and sounding. She was under a lot of stress. Both of her parents just died in a car accident, and she became the instant mother to her two younger twin sisters, that she has to take care of, and can't afford the lifestyle they were accustomed to that their parents provided for them, living somewhere up in North Jersey in a fairly wealthy community. So she was looking for a similar kind of demographic in the neighborhood where it was a mixed neighborhood of people. And, you know, it was a big Black population there, but she was looking for a mixed neighborhood. But either way, it doesn't matter. I can't search for that. I can't talk to her about that. Remember, doesn't matter your intentions, whether they're good or bad, or I want to be by these people, I don't want to be by these people, or I want to be by a mixed group of people. You can't engage in that conversation of who lives in the area. So I just said, you know what? You're not sure where it is you want to be. I'm going to look up some properties in different areas, and you could decide. I'll show them to you, and you could decide if there are areas you like and if you like the houses. So I'll show you a few homes, okay? And I did that, and I showed her around a few homes. She ended up buying a house from me. She even invited me to a housewarming party, and ended up being a really cool person. So you never know with whom you're dealing with, and that's why this thing works, though, because you never know who's going to be a tester. So just treat everybody fairly and equally, and don't engage in any rhetoric or joking around. Even sometimes these testers, they may just start joking around. You know, look, this is a business; it's a job. Don't joke. You become friendly and even overly friendly with people. Just be careful about how do you joke around or how they joke around and chiming in on it, because you never know. They could be a tester. Okay, so treat it like a business and treat everybody as if they're a tester. Okay, and then you should be fine. Okay, so this I believe that was the last slide on this. Yep, we're done with chapter 4. So let me close that out. Let's do the key terms to review for chapter 4, and then I believe we're done for the day. So chapter 4. Key terms to review. Refusal to lend in certain areas, usually inner city.
Steering.
Refusal to lend. Refusal to lend.
Redlining?
Yes, redlining is correct. 9 is A. Using panic selling based on prejudice.
Blockbusting?
Trying to bust up the block. Blockbusting. 2 is B, correct. Protected classes are race and color with no exceptions.
Civil Rights Act 1866.
Correct. 3 is C. Section of the Federal Civil Rights Act that covers housing.
Federal Fair Housing Act 1968.
Section, well, that's a name that it was given, but what is the section?
Title 8?
Title 8, correct. 13 is D. Channeling home seekers to or away from certain areas.
Steering.
That is steering. 11 is E. Statement about discrimination everyone listing property must receive.
Attorney General.
Yeah. Go ahead.
Yeah, the Attorney General's memorandum about the New Jersey laws against discrimination. Correct. 1 is F. Court cases covering moderate income housing. You know, I think the word low above moderate because it was mainly about low income, not necessarily the moderates that were just out of the neighborhood. So right low above the word moderate. Court cases covering low and moderate income families.
Mount Laurel?
Yeah, the Mount Laurel court decision. 7 is G. Specific group that may not be discriminated against.
Protected class.
They're a protected class. 8 is H. Okay, next to letter I, guys. Next to letter I, cross out the word benign. Benign means it's harmless, there's nothing wrong with it, but all discrimination is wrong. Discrimination intended to correct past wrongs.
Reverse discrimination?
Reverse discrimination, 10 is I. And reverse discrimination is basically discrimination against white people, okay? Yes, that is a thing. It is still discrimination. Federal agency enforcing civil rights compliance.
Federal Fair Housing Act, 1968.
The federal agency.
Department of Housing.
The civil rights compliance. I'm sorry, what'd you say?
Department of Housing and Urban Development.
Yes, HUD. In other words, HUD, right? Department of Housing and Urban Development. 4 is J. Undercover checker who monitors fair housing compliance.
Tester.
They're a tester. New Jersey law governing discrimination in real estate transactions.
LAD.
The LAD, the law against discrimination. 6 is L. And federal law setting many protected classes with some exceptions.
Federal Fair Housing.
Finish that? Federal Fair Housing Act of 1968. 5 is M. Is that the only one? Yes, it is. Okay, so that concludes chapter, only chapter